Tuesday, February 4th. We will have the invocation led by Pastor Rob McKenna, followed by the Pledge of Allegiance, which will be led by Mayor Pro Tem Perstuck. And if you could all please rise. Thank you.
Let's pray. Heavenly Father, for me, it's always an honor to be able to come and to begin a meeting like this, starting with you. And so, Lord, tonight, as I always pray, Lord, I'm thankful that in you there is wisdom and discernment, that there's understanding. And, Lord, there's celebration, Lord God, with you as well. And so tonight, Lord, as our council meets, as our community comes together, as our officials, our administrators, our police and fire, Lord God, we're thankful for all of them and, Lord, the leadership skills that you've given them. And, Lord, I pray protection over our city. I pray that you continue to cover us and watch over us. Lord, I'm thankful for what you've done here. And, Lord, even in the difficult moments, Lord God, I pray that you would continue to lead us and guide us. Give discernment to all things. Lord, watch over our children in schools, our teachers, Lord God. Protect our law officials and firefighters. And Lord, I give thanks for this council, for the mayor. I pray that you would continually to bless them and watch over their families. And Lord, may tonight, Lord God, may it bring honor to you as we meet. We pray this in your name. Amen. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Pastor McKenna. Thank you, Mayor Pro Tem. All right, this evening we have a special presentation. We have a proclamation that I'll read. And this is for Black History Month. Whereas Black History Month affords special opportunity to become more knowledgeable about Black heritage and to honor the many Black leaders who have contributed to the progress of our nation. And whereas Dr. Woodson initiated Black History Week February 12, 1926, and for many years the second week of February, chosen so as to coincide with the birthdays of Frederick Douglass and Abraham Lincoln, was celebrated by African Americans in the United States. And whereas in 1976, as part of the nation's bicentennial, Black History Week was expanded and became established as Black History Month and is now celebrated all over North America. And whereas such knowledge can strengthen the insight of all of our citizens regarding the issues of human rights, the great strides have been made in the crusade to eliminate the barriers of equality for minority groups and the continuing struggle against racial discrimination and unconscious bias. Now therefore the mayor and members of the City Council of the City of El Segundo, California hereby proclaim the month of February 2020 Black History Month and urge our citizens to join together in making this period of rededication to the principles of justice and equality for all people. And here to accept the proclamation is our Director of Information Systems, Charles Mallory. Charles.
Thank you, Mayor Pro Tem, City Council. As you have articulated, it's a celebration of achievement for African Americans and Black relative to the U.S. history. So I just wanted to point out a few of those accomplishments, right? One being Samuel Morse invented, obviously, the Morse Code in the 1800s. Obviously, that revolutionized communication at the time. Additionally, automatic elevator doors, I didn't know that one, invented by Alexander Miles in 1887. Item number 3 that I have here is the 3-light traffic light. I'm assuming that it's the yellow part, right? Invented by Garrett Morgan in 1923. And then we have refrigerated trucks, actually invented by Frederick McKinley Jones in 1940. And then the last item that I have here, which is one of my favorites, is the color IBM PC monitor. And the gigahertz chip was co-invented by Mark Dean in 1980 and 1999, respectively, right? And just to close, I'd like to say these are just a few of the people and contributions that have kind of paved the way and inspired future generations. So thank you for the proclamation.
Thank you, Charles. Let's do a photo.
Thank you so much.
Okay, Madam Clerk, roll call, please.
Councilmember Nichol,
Here.
Councilmember Pimentel,
Here.
Mayor Pro Tem Persick. Here. And Mayor Boyle.
Here, thank you. All right, public communication. Now is the time and place for public communication. We do have public communication speaker cards with the city clerk. If you intend to speak, please fill one of those out. If you're here for the matter on short-term rentals, we suggest that you wait until that time. Let's see here, just want to clarify one thing. Yeah, wait until that comes up in item 4, but if you're not here, fill this out. So we've got a couple. First up is Jeff, is that Schultz or Shu? Shu? Yeah, short-term rentals, okay. That can wait till later, please. Thank you, sir. Eileen, later? Okay, I'll hold that for later. Carrie, I know that's short-term rentals. Hold that for later. Thank you. And another Shu. Layla? Right. Okay, I'll hold that as well. Any other public communications? Okay, moving along here. All right, let's see. We have item A, consideration of a motion to read all ordinances and resolutions on the agenda by title only.
So moved.
Second.
All in favor?
Aye.
Aye, 4-0. Consent calendar. Any polls from the consent calendar? No? Do I have a motion to approve?
So moved.
Second.
All in favor?
Aye.
Aye, 4-0. Public hearings. Well, that didn't take long, did it? Item 4, introduction of an ordinance for zone text amendment creating a pilot program to allow and regulate short-term rentals in the city's residential zoning districts through a short-term rental permit process. The proposed project is categorically exempt from the requirements of the CEQA Act pursuant to Class 6, 14 Cal Code Regs 15306 because it involves creating a regulatory process for use in the residential zoning districts for a limited time. This is the time and place hereto fixed for a public hearing related to the matter I just described. City Clerk, was proper notice of the hearing given in a timely manner?
Yes, it was.
Thank you. Has any written communication been received regarding this public hearing?
It has.
Thank you. We've all received copies of that. Public hearing is now open. Mr. Mitnick, who's going to make the presentation?
Planning and Building Services Director, Sam Lee.
For those of you folks in the audience, as soon as he's done, you're going to have an opportunity to speak, okay? Thank you.
Good evening, Mayor Boyles, members of the council. At the November 19th council meeting, staff presented an ordinance to adopt a short-term rental regulations, a pilot program, about 18 months. You heard from the public, and after much discussion, directed staff to come back with some changes to the ordinance. Those changes have now been made. In addition, there were some last-minute discussions with the hosting platform companies and have resulted in some additional changes. Those changes were submitted to the city clerk and have now been passed out. The changes are in section 4-15-10, titled Hosting Platform Responsibilities. Changes reflect a new requirement for administrative guidelines that will come before the council prior to implementation of the program. It will cover in detail specific requirements that must be followed by the hosting platform companies, such as reporting requirements and how homes are posted onto their website. So with that, Greg McLean will go over a brief presentation to go over the requested changes from November, as well as go over enforcement rules and procedures from staff.
Thank you, and good evening, Mayor Pro Tem, and Council. With regard to short-term rentals, I have a couple objectives that I'd like to address today. One is to respond to the comments from the November meeting. I also want to emphasize that our goal is to preserve the integrity of our residential neighborhoods. I think that's very important to keep in mind from the beginning. we're also trying to create a pilot program with incentives to participate and penalties for not participating. We want to clarify how we would intend to enforce this, and as Director Lee said, we're going to work with our stakeholders so that we can find the best possible way to do this. So with regard to the November 19th meeting, one of the very first things was limiting the short-term rentals to the R1 and R2 with special considerations for R3. I'll go into details in just a little bit what we're proposing. There were some operational changes. There was discussion of prohibiting short-term rentals where the ADUs are. Hosting platform responsibilities was discussed. And then lastly, staff roles and the monitoring consultant that we're proposing to bring on board with regard to enforcement of the ordinance. So let's take these one at a time. The zone changes, what we're proposing is in the R1 zone that short-term rentals be allowed one per single-family residence, straightforward. In the R2 zone, one per single-family residence, but also one per duplex. And then R3 would be the same as R2. That's the proposal that we have in the ordinance today. Operational changes, we're asking that there be no signs advertising. That does not exclude directional and parking signs and the like. We removed the limitation at one booking at a time, because I believe that came from the council. Okay, ADUs is now it's covered in state law, but we've put it in the ordinance anyway, just a backup in case they change that. So where there's an ADU, you cannot use it for a short-term rental. With regard to the hosting platforms, we are requiring the platforms to remove the listings when notified by the city, and that would happen in cases where they're operating without a valid permit, either by having it revoked or just never getting one. The platforms are working with the city on ways to block listings, but honestly, this is a technological problem. We may not have a solution right away, but the new permitting system that we're hoping to get online in a year or so should be able to do that, but we're checking. I don't have a definitive answer on that. The collection and remittance of the transient or
Occupancy.
TOT. Okay. Yeah, occupancy, that's right. That's something that's being worked out with the bigger platforms now. And I'm not sure where that's going to go, but that'll be in the operating agreement that will be settled. And they will provide us with quarterly reports letting us know who's been renting that they're aware of and so forth. So let's talk about enforcement. There's a number of roles. One, we're going to hire a consulting firm. One that many of you may have heard of is called Host Compliance. There are others. We're not sure which one yet. But they'll have a certain role to play. They'll be our eyes on the internet looking for short-term rentals and then confirming that they are permitted or not. So they'll monitor the internet. They'll send first notices on our behalf to violators saying, you need to get a city permit to do this. They also gather evidence. They'll take screenshots and stuff. They're also, I don't know if I included this, but they're very good at figuring out what addresses is advertising, because sometimes they don't include that in the advertisement. So they have algorithms and whatever that can sort of drill down on that. They'll share all that information with us, turn over violators to us so that we can follow up on them. And the other thing that they will do for us, if we go with that particular company, was they would create a 24-hour tipster hotline. So if anyone is having an issue with a short-term rental, that's not, say, something that would warrant calling the police, they could call this hotline and then it'll get into our system and we'll take care of it. So code enforcement, they'll follow up on all the tips that we get, and sometimes those tips will come from the compliance consultant and sometimes they won't. They'll come from citizens or whatever. It doesn't matter. Whenever we get a tip of somebody operating a short-term rental, either against the ordinance or not following the ordinance or without a permit, then code enforcement will follow up on that, and they will gather evidence as needed, issue warnings and fines pursuant to this ordinance. I'll get into the details of a bit. Police have a role still, because whenever there's a public nuisance, the police will be the ones to respond if they're called. For things that aren't a party house or a unruly gathering, they'll refer that information to code enforcement for follow-up, and then code enforcement will take it from there with the procedure outlined above. Finance has a role. The finance department will be the one issuing the permits. They will also distribute the list internally and with the consultant of who's signed up, and that includes with the police department, so that the watch commander will have that list updated on a regular basis to pass out to the guys in the field. So when they approach a disturbance, they can check right away if it's also a short-term rental, because it has consequences. Finance will also cross-check for a business license. They'll collect the fees in the TOT. They'll use their standard processes that work for them to investigate tax-related issues. So if someone is, for example, under-reporting, they have methods. I'll get into that in a little bit. So let's talk about enforcement procedures. Operating without a permit, this is a sequential and progressively harsher sequence. You don't have to go through all of these, but if somebody's really not going to get a permit and they still want to operate, then we'll get to the end of this. But it starts off with a correction notice letter, either from the consultant or from the city. After a reasonable time, code enforcement will follow up on that. And if they're still in violation, that's 2 strikes, right? The next one, they won't get a permit after that. The next one is $2,500 citation, followed by a $5,000 citation, and then after that, we're done with it. We send them over to the attorneys for prosecution. Operating with a permit, but not pursuant to the ordinance, code enforcement investigates, they issue the correction notice, there's a follow-up investigation, and if there's 2, then all of a sudden we have a revocation action. So the permit will be revoked. And then it follows the citation process of operating without a permit. As I said before, if there's a public nuisance, the police will respond. If it's an unruly gathering, that's the only chance that permit will be revoked. One unruly gathering. And of course, if they don't have a permit, they'll never get one then, at least not in that cycle. Evading TOT remittance, this is handled by finance. Some of the tools that they use include internal collection efforts, turning it over to a collection agency, small claims court, prosecution, etc. So what we're asking is for a pilot program. Now the ordinance has different dates, and I'm going to ask that you, if somebody decides to make a motion to adopt this, or to introduce it, I mean, that with the caveat that we have these dates instead. So we're asking for this to start on July 1st. There'll be an initial period of outreach and registration push, so there'll be a grace period. And try to get as many people signed up as possible. Then there will be, well, even during the grace period, there will be strict enforcement of egregious violations. So if somebody's dumping all their bottles over the fence in the neighbor's yard, that's not going to wait until the program is on. That will be enforced. Parties as well, if they're unruly. Normal procedures will follow, and we want to get at least 1 solid year so we can pick up all the variation throughout the year. Around October of next year, we'll come back with an evaluation, and at that time, the program can be either ceased, modified somehow, or made permanent. So that's an 18-month process we're proposing. Thereafter, the renewals, if the program is authorized to continue, will be on an annual basis coinciding with the business license cycle. So we have a recommendation that we take the public input today, that we introduce this ordinance with the direction to set the period of the pilot program from July 1st, 2020 to December 31st, 2021, and then schedule the second reading. So that concludes my portion of the report. If you have any questions, I'll be happy to answer.
I have one question.
Yes.
What's considered a reasonable amount of time?
Yeah, that we were discussing that today, and we didn't have an answer. That's why it says reasonable. It's somewhere between 3 and 6 months, probably closer to 3 months. Maybe 4 months, maybe 5 months. We'll see. The idea is that we want to get an entire year of operations, plus we want to have a little bit of buffer at the end so that we can come to you before the program is over. So whatever's left would be
that time period is fine. It's just under the enforcement. It said code enforcement is after a reasonable amount of time.
No, the reasonable amount of time would be to get people on board. So if there's violations during that time, they're going to be enforced. That,
Okay, so we're saying after July 1,
yeah.
it's been a reasonable amount of time.
Well, July 1 would be the start date we're recommending. So maybe 3 months or 4 months of getting people to sign up. What we won't be enforcing is people who haven't signed up yet, because we're still trying to get them on board. What we will be enforcing are all the rules pursuant to this, whether they're signed up or not. So regards to trash, parking, noise, all of that will be enforced right from the beginning. Actually, we could enforce that now even, and we do if we get a complaint. And then starting around, I guess, November or so, then we start also enforcing the need for a permit.
So I have issue with that because you're basically encouraging people not to get it till November.
Well, actually,
I mean, if you put a date out there and if you do outreach, then the date should stick.
okay, that's reasonable. The reason why we want to do it, though, is there's actually an incentive to get on board early, because your first term will be 18 months rather than a year. So for the same fee, you get 6 extra months. So there's a little bit of encouragement and discouragement. I'll agree with you.
I don't like to reward bad behavior.
The dates of the program are entirely adjustable.
I mean, I understand maybe a 2-week period, but not a 3-4 months.
Are you talking about 2 weeks to become registered as STR?
Well, July 1st is the date. So if we do an outreach and start the outreach in March, and we're doing complete outreach and we've notified people and they haven't got the permit by July 1st, the first time they get that notification, hey, you don't have your permit, that,
Well, yeah, because the way I understood, if you go back to that slide, was,
Was it this one?
keep going back.
No, this is the one with the initial outreach period.
You know, but go back. Right
first
there.
one.
Correction notice letter from consultant or city,
Yeah.
followed by the code enforcement after a reasonable period. So that's
Oh, okay.
That's
This
the
is a different
reasonable
reasonable-
period. Yes, so that reasonable period. So what is
Right.
that reasonable period in your definition of reasonable? Because I'm sure the person living next door to it's definition of
Oh, yeah, yeah,
reasonable,
yeah.
it might be different.
That is probably something on the order of a week or maybe 2 weeks.
can we
and-
just state
Can we,
it?
yeah, can
Yeah,
we just
no,
stay
state
with
it.
that?
no, I totally understand, but that
Yeah.
was, yes, from my definition of
Yeah.
reasonable. And I
Okay.
think that there's some precedent and procedures that code enforcement follows, and we'll try to stick to that, but we will also be aggressive, because if it's, obviously if there's a problem, we're not gonna wait.
If I might add, the word reasonable is not in the language in the code.
Yeah.
This is what staff is saying, and just as an example, there are situations when we're dealing with individuals where reasonable time period can mean different things. If someone's healthy and able to get things done, a few days is all really it should take. But let's say, we do deal with individuals, they could have a, unforeseen health problem, something like that. So we might give them an extra week or so. So when they use the word reasonable up there, whenever we're doing code enforcement, we have to kind of take situations. But I understand what you're saying, but the word reasonable is not actually in the code language. That's just how we deal with individuals, and that doesn't mean months, just for
Yeah,
explanation.
I think some of the clarifications, we know that with code enforcement, asking someone to take care of all their cats might depend upon who has all the cats and things, but this is a far more, this is a commercial exchange, so we would like to probably take some of the guesswork out of that, as I suspect.
Yeah,
where
and
we're
that can be
going.
addressed in the operational manual that we're going to produce, which will also come back to you. But keep in mind that when, at this stage, operating without a permit is where that language appears. That's not necessarily the kind of problem that is going to make a neighbor upset if it takes a few extra days. Dumping trash, making noise, disrupting the neighborhood by taking all the parking on the street, those kinds of things, we will not wait a week or two. Those are immediate concerns, and so I apologize for the confusion. We will absolutely be enforcing that stuff vigorously.
But I do have to say,
Yeah.
you say it doesn't impact the neighbors, but we are spending money to monitor this, and these permits is what's paying for this monitoring. So if we don't collect the money to pay for the monitoring, that's coming out of the general fund, which means it's coming out of everyone's tax dollars. So I disagree. It does impact people, and people need to understand that. One of the main reasons for doing this is that there's a cost to it, and we need to cover those costs.
Yeah, as I said, we'll take direction
Yeah.
from the council.
And then and in this, it's good. I just do have one other question. We said the one per residence earlier in the.
For the
about-
single-family homes,
Yeah,
yes.
but then we said multiple bookings. Is that for R2 only?
No, I believe that covered everyone.
Well,
was-
if you can only have one, how can you have multiple?
No,
bookings?
One-
think of
one
like,
permit.
think of
One-
4-bedroom house, and they might have one guest in one room and one
But we
guest in
said
another.
only
Yeah,
room.
one.
Yeah,
it reads, the ordinance does read as if it's only one bedroom
Yeah, it's
or
not
one
intended to.
booking.
And I'll tell you the reason. There's opportunities for like families to get together from all different corners of the country, and they'll have different arrival times and so forth. They might all want to be in the same house, but they may do independent bookings so that, that one person isn't paying for everybody.
But
That's
go-
one example. And
But go back to that first slide. I believe it said,
yeah, it says one STR permit, but the permit allows you
I
to rent
see.
multiple rooms.
got you, okay.
And now keep in mind that the number of rooms that can be rented is also controlled by the parking available on the property, not on the street. So if they've only got enough parking to accommodate 2 bedrooms, even if they have 4, 2's the limit.
Got it, okay.
Okay, any other questions for Mr. McLean before I turn it over to public input, Chris?
I've got heaps. So
Sorry,
some of these are less questions than me adoring my own voice, but I would suspect that we would want a monitoring platform irrespective of whether we have a pilot program or not, because these will exist, and we have a need to enforce them whether or not we have a program to allow them. So I think that in terms of the money spend, I think it is out there as a budgetable item, because these things will exist whether or not we have a program to legitimize them, and it is our interest to know where they are. So that is a postulate. This one a bit for the city attorney. The nature of a pilot program, and I think for all of our edification, the nature of the pilot program means that someone who is granted the ability to have a permit for a short-term rental now or July 1st would not have any right or recourse to continue that in 2023 if we no longer have a pilot program, correct?
That's correct, and that would be in 2022.
Or,
So,
well, yeah, at any point in the
Yeah,
future after this
yes.
pilot program. The point being is I think we had pointed out at our last meeting, there was a series of litigations across the country for an ongoing usage right that we want to make sure we're not creating exposure for.
yes, this was designed for the purpose if the council were just to make these permitted by right and not a pilot program, then the ability to undo that becomes very difficult, because once you grant a permitted right, the law basically says you then, even if the city were to say it's no longer permitted, they would be grandfathered in, and so they would be legal non-conforming. So this was done intentionally so that the city could implement this program on a trial basis, but if it determined at the end of this time period that it was not desirable, then you could revoke it, and individuals would not have the legal right to continue.
Do we have the ability to revoke it before then?
Not the way it's currently worded. We could add language to make that possible.
If at the end of that, if we like it, but we're still kind of not sure, do we have the ability to do another pilot program, or are we thereby creating a right?
I think that if it continues for too long of a period of time, that would be a concern, and that would be something that you should address at that time, if you want to continue, and we can provide some additional briefing, legal briefing on that before you get to that point. But if you had a pilot program that just went on and on and on, then that would be problematic.
In this, we have two things that I think are being used very easily by us but might be confusing to the public, and that we have a police function for loud and unruly parties, right? That's a police action, that's a civil fine they put in, a civil action. But similarly, by this ordinance, you're not allowed to have any gatherings if you are a short-term renter, correct?
Well, no, obviously you can have gatherings, you just can't be loud and unruly.
It says in here that the only purpose of this has to be for lodging.
Right, but that could be a gathering. I mean, like I said, if you had people coming from different parts of the country, that could be considered a gathering.
Well, there'd also be renters lodging there, but if you invite
Right.
people over for what a policeman on a Saturday at noon doesn't find loud and unruly, but
Right.
because it's the 52nd Saturday in a row for the neighbors, they consider it just loud enough to make them want to lose their hair.
I see what you mean.
Is-
Okay, that would trigger a code enforcement action then.
Okay, that is a violation of this.
Yes, it is,
So,
because the rules in the ordinance state that it's for overnight lodging only.
so loud and unruly is currently against our municipal code.
Yes.
This would make just a gathering in violation of the short-term rental pilot program.
Yeah, a gathering that is, you know, like you said, the example occurring in the daytime and every weekend or something of that nature, that rises to the level of a nuisance.
Okay.
Well,
Maybe
wouldn't
not
it be a
the-
gathering exceeding a certain decibel level?
Yeah,
I
I
thought I
mean,
required there was a sound contour.
Again,
that
if there's no
yeah.
complaints, there's probably going to be no enforcement there.
Well, but I think that, remember, one thing that we do here is we're putting the burden of enforcement principally on neighbors who are already being inconvenienced. So no matter how easy we make that mechanism of reporting, but we owe it to them. If we're commercializing part of our residential zone, then I think that it's important that this thing make clear what the limitation is. It says in here it's for lodging. So if I live next door and they're hitting the piñata for the 51st Saturday in a row, you know, I want to be able to say, look, this is not this is not for lodging, right? That's because you're using the pool to have a birthday party, again.
I think there's going to be shades of gray in that, and I've read these situations where some of these have been used for, like, weddings, I mean, they're rented out commercially for weddings. I think that would be potentially, from a code enforcement point of view, going after that, you're really, you're renting it as a venue. If people are just gathering as part of being, staying there, and they're in the backyard, outdoors and whatnot, I'm not certain that we could do really much about that. Now, that's one of the things at the end of the year that you may look at and say, how big of an issue is this? Is this really occurring, or is it not a problem? And I don't know how that will turn out, but it would be difficult for us to enforce people just socializing outside on a regular basis.
Well, I suspect, I mean, there's nothing in here that prohibits guests, and I certainly don't want to belabor that because this is the reasonableness notion, right? But we have a code enforcement person who we're going to trust to say, you've changed it from a lodging to a venue, on the one hand, but we're also compelling the neighbors to be the bad guy here and say they're using it as a venue, which is a minimum uncharitable to them. So I think that we should bear that in mind in the language of this, that, you know, lodging, we say it's for lodging, then I think we need to mean it's for lodging. And there's a reasonableness to, I guess, having some guests, but using it as a venue is not the intent of this. I would wonder also if you could clarify, and I know that we danced around this a bit with the ADU piece last time, of making clear to people, because ADUs specifically under state law cannot be used for short-term rentals, and by our ADU ordinance cannot be used for short-term rentals, how we define the difference between an accessory dwelling unit and what is a short-term rental space, and what short-term rental spaces need to have. You know, we have a picture in the documents for you. Someone submitted a picture of what looks like a tool shed being offered for rent. Can that, under this, be offered for rent?
This ordinance is silent on that, but there are other laws and ordinances that prohibit lodging, especially overnight, in a non-habitable space. So that would be enforceable under those.
And when is something an accessory dwelling unit that can't be used, even though it is a habitable space?
Yeah, accessory dwelling units have to have cooking, eating, sleeping facilities, access to restroom of some, you know, could be in the other part of the house, for example. And basically all of the needs for and its own exterior, ingress, egress, or door, if you will. Those are the minimum qualifications for an ADU. Now, it gets tricky because, you know, you can have all of that and not rent it, except for the kitchen part, but you can have all the rest of that and not rent it, and then it wouldn't be an ADU. But if you have a kitchen, that's usually the giveaway.
Would our monitoring platform note those attributes? So if someone has something with exterior entrance and a kitchenette and it's dwellable and they want to put it on as a short-term rental, would that be flagged and say you can't rent it as a short-term rental because that's an accessory dwelling unit?
Yeah, and that would be picked up in two ways. Whenever they come, if they come in for a permit, that list or the list of recent permits gets circulated among the city. And when planning gets a hold of it, we'll check. And if there's an ADU that raises a red flag, we'll start investigating that. Because it is conceivable that they're renting a room in the house, separate from the ADU issue. And that's possible. So we'll have to investigate that, but at least we'll be alerted to it. And on the other hand, if they do not, then I guess it's fair to assume there's probably something happening, so we'll investigate that as well. Now, the other thing is, a lot of the listings will show photos, and if they're showing photos of what is obviously the ADU, well, we've got evidence then.
And we suspect that we will have compliance from those hosting platforms to participate. And even if they don't, in theory, the monitoring platform would find these things being rented.
Yeah, I would say
contravening
that
this.
the hosting platforms will participate to the extent that it's actually technologically possible for them to do that. But they won't commit to doing things that they're not capable of doing. So what you have to remember is these are technology companies. They're big on algorithms and very, not so much on people. So if you mail them a list of these are the approved ADUs, it's not going to do anything. There's no way for them to key that in for every city in the world, right? But if we made our system available for them to reach in and check, they'll do that willingly. That's the goal. But that won't be at least for the pilot program. It won't be in place.
It will not. They will not be able to do that for the pilot program.
No. So instead, if the host compliance or other consultant finds one of these and lets us know, then we call them up, and under the terms of the ordinance, they would remove that one. They'd remove that listing, and they would also inform the host why, and then let them know that they have to get the permit.
And is host compliance, are we able to, on the new website, are we able to link our systems where if someone had a complaint on the new website, they could just key a tile there and enter their complaint?
Well, the new website has the ability for people to file complaints or to notify us of violations of all different types, and certainly this was one that we expect to get there, and it would be routed to code enforcement.
My last one was about TOT, but given the lack of interface with the hosting platforms, I think that is probably a question for 2 years from now if we go forward. I think my last one would be, do we know of any other surrounding cities that are using these platforms with success, or using the monitoring platforms with success?
Yes.
Okay.
A lot of cities do. I know for a fact that Hermosa Beach uses that platform. They're one of the early adopters of it. They're using it in a different way, but a lot of cities use these. I mean, I would say probably nearly all cities do it because it's too much to hire a staff person to do what an algorithm can do for free, essentially, once it's written.
I believe they use it in Hermosa specifically, they use it on the one hand to enforce a ban in their residential zone, but to regulate their usage in their commercial area where they have, where they have conditional uses. That's all I have.
Thanks, Councilman Pimentel. Any other thoughts before we go to public input? Yeah, go
One
ahead.
other thought. I believe it was discussed at one point, the question of property having to be owner occupied.
Yeah.
So reading through here, it says that an owner has to be available by phone 24 hours a day. They have to respond to the first phone call in 2 hours, and then resolve whatever the issue is within 24 hours. But nowhere in there does it say that they have to be owner occupied.
That's correct. What we are saying is that it has to be the owner's primary residence, with the exception of the duplex, but they have to own the building and live in their primary residence in the other unit at least. That's a little bit different, but we didn't get clear direction that it had to be owner occupied, meaning the host is there with the guests simultaneously. So it's not included.
So is there anything in here then that would protect us from having, say, the people that are looking to profit off of this come in and rent out an entire apartment building and start doing it?
Yeah, well,
Or rent out a house and start doing it. They don't live there. It's owned by a company.
it has to be their primary residence.
Is there could you foresee any loopholes in that? I mean, if it's owned by an LLC,
I can, but I don't want to reveal, but they're very unlikely and very specialized circumstances. We're going to include this in the operational manual that we'll produce, and we're going to need proof such as, redacted tax forms from the last year, driver's license, things like that.
and
In respond to your question, Councilmember Nickel, an LLC shouldn't be able to qualify to have a short-term rental because there is no, it's not set up legally that way. So that shouldn't be allowed. Now, you could have a property in a family trust, but then that identifies the family. But to have a corporation or partnership of some type, that would be very difficult for them to qualify to have a short-term rental.
okay. And then next question. If, let's say that there's a loophole that we do not see right now. We don't foresee it, but someone else does, and they start taking advantage of it. Can this come directly back to us during the pilot program and we
Yeah.
can amend it at any point?
If it's a problem, yes, absolutely.
Okay.
I would follow that because that's something, it is, by primary residence, how many days a year? It's 185 or something? I mean, how many days a year do they have to live there?
Oh, I think if you follow IRS rules, it's
Just
half the year
standard
plus
Board
a
of
day.
Equalization, sort of half the year plus a day. What about if it's somebody who is, if it's a permanent home of record, but they ship captain and they're on military orders, any of those sorts of things, are those the sort of weirdo
Yeah.
oddballs?
If somebody decided to take a world cruise and be gone for a year, I think they would have found a loophole. Because if their mail is still going there and they're obviously not listing their addresses somewhere in the middle of the ocean, then I guess that's still their primary residence.
But would they have to have a designated agent to respond within 2 hours?
We need to be able to get a hold of somebody, so yes, they would.
And the owner on title is the one that has to pull the permit, correct? The tenant cannot?
I think that's probably reasonable, yeah.
Be owner occupied, so, and we require for permits, we require the owner to sign for permit applications.
No, I understand that stipulation because you can,
Yeah.
and you can file for a permit without technically being the owner of a property. I guess what I'm looking for is, I know that that's something that can happen, but if you have, say, a renter that says, hey, this is what I want to do, go to the owner, this is what I'm going to pay you every month, let me do this, I just need you to sign this piece of paper to allow me to pull the permit.
I would say that's not owner occupied.
No.
I think that the case where someone other than the owner living there might be, the son or daughter of the owner, that's possible. But
It's not the owner.
in the case where it's a renter unrelated to the owner, I don't think that would qualify as owner occupied.
And just so you understand my reasoning for asking this question and then ultimately asking if we could potentially make it where the permits can only be issued to the owners of record, is that an owner, I think, cares more about their neighbors and ultimately their neighborhood than, say, someone who's a tenant there looking to make money off of, say, a loophole that they found in the code. And I think anyone in our residential zone would feel the same way, that there's more of a onus put on someone who lives there. These are their neighbors. They're not moving. Whereas like someone who could say, yeah, I'm giving my 30 days, I'm out. And so,
Well, that was our intention when we included that language. So if you think that needs to be beefed up a little bit, just
I just think the permit should
Make that
only
the
be able to be
direction.
issued to the owner
It's
of the
owner
property.
occupied, and to respond to the suggestion Mr. McLean made is if they want their children to live there, then they're gonna have to put their children on title. And there are, issues that surround putting your people on title, so they would need to do that and prove to us that that person's on title. And there is a cottage industry out there of people that rent places and then relet them as short-term rentals. And so that would not be permitted under our ordinance.
So just for clarification, Greg, are you asking from us, do we want to beef up that language?
no, what I'm saying is if that's the direction of the council, we'll do that.
Should we vote on,
No, we're not voting right now. We're going to take public input after we're done with Mr. McLean, then we'll come back, have council discussion, okay? So any other questions for Mr. McLean or comments?
None.
Okay,
Thanks,
thank you,
Greg.
sir. All right, now's the time and place for public input. Now, I've received about 4 of these so far. Oh, city clerk's got more. If you're here to speak on this item, please get these into Mrs. Weaver as soon as possible. I think I've got a duplicate here.
You might.
Okay. All right, first up is Mr. Shu, Jeff Shu, followed by Eileen Later. And if, Ms. Later, if you could be ready to speak as soon as he's done. And remind everybody you have 5 minutes, please. Thank you.
Well, I have a lot to say. I had things I wanted to cover, but I think after hearing what I heard, I have more questions than my previous comments. But I would like to say that you know, the arguments for SDR and arguments against, we've heard them for the past year, and they're not going to change. I happen to be against short-term rentals because of the experience, personal experience I've had. In November, you did have a meeting where you had victims of AB 1482, and you addressed that. But I just want to make a comment that I think the proliferation of short-term rentals exasperate that situation of unavailable housing here in El Segundo. But there were things that were covered in the presentation that I wonder about. Is there any kind of criteria that you will use to judge the effectiveness or the viability of this pilot program, so everyone knows up front? Am I just going to ask the questions, get answers, or does my 5 minutes just...
You're going to ask questions, Mr. Shu, and then at the end, if council so desires, we'll address any questions and comments from the public input.
Okay.
Thank you.
Okay, another comment is, we talked about enforcement, and the eyes and ears on the ground, as Mr. Pimentel had noted, clearly falls on the shoulders of the neighbors and residents. We've had that burden the last 3 years, and it's not a pleasant burden to carry. And I just don't know how you're going to monitor all of the other restrictions. The loud noise and unruly gathering is easy. The other ones will not be, and they'll still be on the backs of the residents. I don't think there are very many communities, by the way, that you can find that say, wow, short-term rentals has been a boon to us. All of us just really like it, even the neighbors of all the STRs. And I think that if you think that we're going to have the proper regulations, the other communities just did not know how to do it right, that we're not going to have any problems. I think we're living a Pollyanna existence. I have a question on the owner-occupied. If I had an auxiliary dwelling unit and I lived in my house for over 6 months, could I then move to the auxiliary dwelling unit, ADU, and rent my house out for the other 5 months on a short-term basis? Or does the house then become the ADU? Do you understand what I'm saying? The question? I don't know. I think that's something that you have to look into. Now, I saw that in the proposal, you talk about a maximum of 2 adults per bedroom. What about children? I didn't see anything about children. So you could have 2 adults per bedroom and 2 children in the bedroom. So if you had a 4-bedroom house, instead of 8, you have 16. And what constitutes a child, by the way? Can you have 8 17-and-a-half-year-olds having a big party? And maybe you should identify what is a child. Maybe parents come in and they bring their college-aged children and their buddies. So I just think that you have to look at making a maximum and defining children. I think you asked the question, does the owner have to be at the premises? And I'm not sure on that. And I think that those are the primary questions that I would have based on the presentation that I saw. And I thank Mr. Pimentel especially for your points. Thank you.
Thank you, Mr. Shu. Mrs. Lader, and then followed by Carrie Becks.
Hi, my name is Eileen Lader. I'm a resident of Rhode Island, and I've been a short-term renter in El Segundo for 6 years. And I'm hearing a lot about loud and unruly renters and people heaping garbage, and I want to give you kind of the other face of some of the short-term renters in town. I'm a retired social worker, and my husband, who's here tonight, is a financial planner. We come here to escape New England winters. It gets pretty cold. This has got wonderful weather, and it's a wonderful community, and our children and their spouses live nearby. Probably in the 6 years that we've been here, we've met some of the nicest people and people who have become lifelong friends to us. Many of the people are grandparents who came to see their grandchildren's dance recitals, and this was a nice place to stay in another unit. Or we've seen parents who are taking their kids on college tours. We've seen some young people who are doing a job change and they're trying to figure out where they want to live in the community, so they've stayed at a short-term rental so that they could see what else is going on in the community. And the other thing is I've met some really wonderful people from all over the world who come to vacation for a short time who have been like really lovely people. We feel like community members here. We go to restaurants here. My husband celebrated his birthday at Chef Hana's on Saturday night. We bring our children there. They bring their children from other communities there. We bring business into the community. I use the laundromat. I go to Nancy at Queen's Nails. I've been going to her for 6 years. She smiles when I walk in. My friends now go to Queen's Nails. I bring my books to the Goodwill store. I save my jewelry to be repaired at the jewelry source on Main Street. I won't bring it anyplace in Rhode Island. So I use this community. I like this community. And as we use places in the community, we introduce other people to that as well. We use medical services in the area. At this point, we have a dentist, we have a surgeon, we have dermatologists, we have a veterinarian. We feel like community members. Yesterday was a really windy day here. It was also garbage pickup day. Instead of lobbing garbage over the fence to people, I was the person who walked down as the garbage is spread all over down the alley because they don't do such a good job. I pick it up. I put on the gloves. I pick it up. I push people's garbage pails. I turn their plants over. This is our winter home. And it's important for me for the council to also see that people who rent here short-term really love the community. It's not just a bunch of party animals. If in fact we could not rent short-term, we would not come back. I'm not interested in spending 3 months in a hotel. It's just not the same thing. We're quiet, we're respectful, we're law-abiding, definitely not party people. And I just would like you to kind of keep that in mind and realize that it would really be a travesty to kind of lump short-term rentals into a bunch of people who don't do things for the community. So I just wanted to add my 2 cents there.
Thank you, Mrs. Lader. Okay, next up we have Carrie Becks, followed by Laika Shu.
Hi, everyone. Thank you, Eileen. Eileen and her husband stay with me, so I'm really pleased that they came. I'm pleased with some of the changes that you're all suggesting. I think that they're good and they're positive. One of the things I wanted to, I think I wrote to Mayor Boyles that I would volunteer also to help. So I know the short-term platforms. I know Airbnb, I know HomeAway, I know Bookings.com, excuse me. And I know the ones that are accountable and the ones that are not, and the ones that I absolutely wouldn't use. So there is a safety in using a resource like Airbnb, their insurance, their accountability, their customer service, those kind of things. I can certainly volunteer and help other hosts. I think that the pilot program is good. I think, I'm not sure how much a license or a permit will cost. So I don't know if they went over that. I did bring the city council members a brochure. It's a welcome brochure it's something that the city of Paso Robles, they just put some restrictions on the short-term rentals. So they have owner-occupied and they have non-owner occupied. They require, they gave a limit of the permits. So I was at the Jewelry Source and we were chatting, and one of the concerns was, what if our whole city becomes Airbnb or short-term rentals? You can limit that with the amount of permits that you decide to hand out to the residents here. So that's one way also. I think the city of Paso Robles, it's about the same population, and they give 300 non-owner occupied permits. But currently, we only have around, I think, 80 short-term rentals here in the town. So if you look at over the last 10 years, to only have 80, it's not a lot. So I brought some copies of a Good Neighbor brochure. It talks about, our previous speaker was talking about children and how many people can be in a room. Well, they've kind of laid it out in the brochure, along with some parking restrictions and how many cars you can have and things like that. So I thought it might be helpful. To have your neighbors informed is also something that's very good. That they know that there's a 800 hotline to call if there's a problem. I have all kinds of stories, but I will give just one last story. My neighbor called me. He was furious at 1 o'clock in the morning, and I wasn't at my house. There are people in the alley and they're loud, and his bedroom is on the alley. So I said I did rent my guest house. It will, it can sleep 4 people. And so the next day I called Airbnb and I said, I want these people out. They got them out immediately. It wasn't them. It was my next door neighbors, their teenagers that were having a loud party and whatever. So sometimes the people will point fingers at us, and we have to be careful with that as well. But I think it's all about education. It's all about informing our neighbors and letting them know, maybe make it a requirement that the neighbors or the people that own an Airbnb inform their neighbors, their immediate neighbors, that they are running this. The other thing, in San Francisco, they have a lot of renters because it's so expensive, and our city is really expensive as well. They do allow renters to have Airbnbs if the landlord says it's okay. So, and I do disagree with if they're going to want to take care of their property. The example is here, just a small example. Eileen, who takes care of our town, and
Your 5 minutes is up.
okay, thank you.
Thank you,
Thank
Ms.
you so
Bex.
much.
Appreciate it.
Yes, and
Thank you.
I have these brochures.
You can hand them to the city
Okay.
clerk. She'll give them to us. Thank you. Okay, Leica, followed by Leica Shu, followed by Leica Shu again. I think I got a duplicate. Gary Schmuck is up after Leica.
Good evening. It's Layla Shu, but
Layla,
it's okay. Yeah,
my apologies.
it's okay. Sorry about my. I heard a lot of these hosts telling how wonderful they are, and I absolutely believe that they are. But that's not the issue here. Nobody's saying that we don't have wonderful hosts and wonderful places where people can stay from all over the world. I've traveled a lot. I stayed in horrible places, good places, and everything between, so I know what it is. But allowing short-term rentals in El Segundo will definitely change the whole fabric of the town. We already have a ton of them. We have people subletting apartments, and usually when you look down, the host usually has at least 3 listings. There's one guy from San Diego has 10 listings, only one in here. So it's a big business. And I don't want to be part of, oh, the neighbors have to learn and the neighbors have to do this. I'm effing tired of being the crazy lady in my block who calls the police, who has to monitor. I don't want to monitor. It's not my job. I do not want to be involved with anybody's business because they are making money and I'm supposed to look, oh, there's somebody on the alley now. I'm doing it enough now because we have a big problem there. But I am sick and tired of that, and I don't think it's my job. I'm retired. I worked as a nurse in ICU. I've done my deal. So why do I have to be part of this? I do not want to be a part of this. I do not give any consent to you guys to run any kind of pilot program. You'd have never asked me. I know that some of the council, planning commission people went and talked with the hosts. They never approached any of the people who are against short-term rentals. And why is that? Is it only one side? Is it only one side whose opinion matters? What is it? There's a question also how to monitor the short-term rentals that are here, that if you don't allow it, it's going to be a bunch of rogue renters. It's the same thing as you would do by allowing the pilot program. You use an outside company, they will kick out, cease and desist, whatever, kick them out or whatever you have to do. It's not different than anything else. It's not impossible. And what else I have here? I think that we should let the residents decide. I think the residents are the ones. There are a lot of people who are quiet. I've been on the social media. I know you guys know. You look into that. I've been called a Russian agent, whatever, and bad names. They check all my personal information. I really don't care. I know who I am. I don't care what people call me. But this is getting out of hand, and I'm not the only one who feels like this. But people are afraid to say anything because they want to be good friends with their neighbors. They would never say anything. But our neighbors are really united in this. And I hope we don't go through this pilot program. That's it.
Thanks, Leila. Mr. Schmunk.
Good evening. Sorry that I have to be in front of you again. This probably, I don't know how many times in a period of over 4 years in front of the council and planning commission. I am not for short-term rental in any form. Just make that clear. I'm sure you already understand that. One question, I don't understand why this can't be on a ballot for a vote by the city, something that is going to so largely possibly affect the fabric, feeling, or atmosphere of the city. I mean, this is a pretty dramatic thing that we're going to possibly attempt to do here. Just as an example, my wife's cousin, who lives in Connecticut, in a quiet little cul-de-sac, now out of 5 homes, has 4 short-term rentals around her. She's the only one that isn't, okay? So that's what can happen, and it's not a very pretty picture. Us already suffering with one near us is sufficient. I can't imagine when the people to the right of us who are not young put their house up for sale and what's possibly going to happen with that. Currently have no idea what is, if I went to sell my house today, how badly my value would be damaged by the knowledge of the situation that's taken place behind me, that's gone on for over 4 years in 2 different situations. My other question is as long as we're going to make this all about money, can I sell timeshares in my home? Has anybody thought that one through yet? If I'm going to maximize income, is that a possibility as well? Also, we talk about swift enforcement here. In my personal direct experience, having had to appear in court, spent Christmas Eve wondering if somebody who was supposed to vacate a building was going to do it on time and not cause me retribution because of my appearing in court. What were you doing on Christmas Eve? So just what's gone on with us is I have absolutely no history that this city is capable of swift enforcement. It's been anything but swift, okay? I know we put the party law in place, that's great, but still everything moves pretty darn slow when you're the one that's suffering. And the other thing is I'd like to make sure that in any of this, the owner and not the renter is held ultimately responsible for all goings on and situations at the property, because we've seen examples where the owner ultimately gets off scot-free because they're not held responsible. It's they went that way. And that's not really going to work going forward very well. We bought our home here in 1993, back when El Segundo was called two things, Mayberry and Smell Segundo. We actually had the opportunity to buy a home in the tree section of Manhattan Beach. We instead selected El Segundo because of the tree-lined streets. We lived 2 blocks from Main Street, thought the hometown feel was really something great. Can really appreciate all the new restaurants, all the new development. That's wonderful. I just didn't buy into living in a hotel zone, and I have a real problem with that. And I know there's all these great stories about that, but that's not what I bought into. And the only thing with the short-term rentals is there's a whole lot of people benefiting, as well as the platforms and the people renting and the people that get to rent. But there's no benefit for the neighbors. There's no upside for me. It's just a revolving door of people coming and going in the neighbor's house or at the neighbor's house. And I have a text I'd like to read when I had reached out to one of our fellow people that was against the short-term rental. And he's become so discouraged he didn't want to appear tonight. And it says, "Hi Gary, thanks for the heads up, but I'm afraid our current council is focused on revenues over community, and the frustration with them is just not worth it anymore. With winter here, it's been much better." He has the second worst short-term rental behind him. "It's been much better, but I have diminishing hope that it will hold. With summer and the SoFi Stadium coming, I think it's best to find a summer home well away from El Segundo. I know your situation is a lot worse and hope the party ordinance will help. Best of luck in your battle.
Your 5
Gino
minutes is
Aveni."
up.
Thank you.
Thank you, Mr. Schmuck. Any other comments? I have no other cards. Okay, we are going to address a couple questions that haven't been explicitly addressed this evening. One is, as we've said, Scott, Mr. Mitnick, on several occasions, whenever we roll out a pilot, we've talked about the effectiveness. How do we measure the effectiveness? So specific outcomes in mind, criteria. I don't know that we've established those, at least not that I've read, so something to think about as I go through this list here. Enforcement, we talked about. There was an interesting question about if you live in the house 6 months, could you move into the ADU and rent the house? I think they know the answer to that, but I'm hoping Mark could address that one. What about child, how we define child as far as capacity of the short-term rental dwelling unit? And then cost of license permit, I think we've addressed, and it's in the staff report, but you might want to touch on that. And then just maybe remind everyone, Scott, what our anticipated revenues will be. I know they're listed in the staff report with the license fee and the TOT, and what we stand to gain, or more importantly, lose with this program, and remind everybody about our cost recovery opportunities there as well. So if you could just touch on those things. Do you got them all? Okay. I'm going to start with the the success criteria for the pilot.
I don't believe we have the specific measures in place. I don't know if staff would like to comment on that, but we would absolutely use those as we go through it. So Greg, maybe you can elaborate.
At this time, we don't have them, but as soon as I heard that, I realized that was a mistake. We should have some, and we'll have some for the next time.
One that came to mind for me earlier today, Greg, related to the number of ADUs.
Yeah.
Another acronym, government. Number of STRs that we currently have, at least to the best of our knowledge, using these other platforms, maybe once we stand that platform up, and then how many we have in the future. So are we seeing growth in them and maybe even density of short-term rentals per block or per, you know what I'm saying? Per precinct, so we're not inundating particular blocks, or at least understanding the impact that.
Yeah, I think in addition to having success criteria, I think we should also be making a heat map so that we can identify if there's some places that are overexposed and others that are, not taking advantage, and figure out why.
And then obviously number of violations.
Yes, obviously.
And fines, citations, et cetera. Okay, any questions regarding success criteria for my colleagues while Greg's up here on that one?
Not on success criteria, but I have 34 other ones.
Let's hold off then. Let me get through the others then. For Greg specifically?
Some of them, yes.
Okay. Let's go through the rest of the list then. The question mark about living in the house for 6 months and then moving to the ADU and rent the house.
Well, the way the ordinance is written, that would not be permissible because the ADU is not considered the unit that's subject to a short-term rental. So they need to live in the unit. In the R1 zone, they would need to live in the primary structure for 6 months. The ADU is not allowed to be used as a short-term rental. Now, in the R2 zone, where you might have a duplex, I guess in theory an owner could move back and forth. I don't know what advantage that would be. But in the R1 zone, the owner has to occupy the primary dwelling for 6 months. And the only thing, and I think one of the things that we're going to wrestle with the ADU issue is, because of the new language, you could in theory have what is essentially a duplex, where both units are under one roof and they're identical. And we're going to have to require them to identify which one is the ADU.
Okay. Greg, what about the question about how are children defined? Do we have children defined in terms of capacity? There's a question about could you have 2 adults and 4 kids, or whatever the example was, in a room.
I thought that might be something that we can address in the operational manual. So that will also come to the council for approval.
Okay, bear with me, then we'll get to Chris's. The cost of license permit, and then just kind of the philosophy around cost recovery. Scott?
Mr. Mayor, members of the council, before I answer that, rest assured that we will do everything in our power to make sure that this new program pays for itself. And if it's not, we'll come right back to council to make the necessary adjustments. So as delineated in the staff report, it's estimated that the revenues in the first year may be $162,000, $125,000 is the estimated TOT, and then the remainder, $37,000, is the estimated permits and business license. That is a relative rough estimate. And then on the expense side, how much will it cost as a result? There's $40,000 in here for a budget appropriation for the consultant. And then, of course, there would be the cost of code enforcement staff, police staff, and then the rest of us who are involved in various forms. But we will make sure we're documenting what the cost impacts are and the revenues that come in. It is not the goal to lose money on this, and we're not pursuing this at the staff level as a moneymaker. We're reacting to the requests from the short-term rental community.
Yeah, so if there's a $110,000 delta roughly of what we anticipate in revenue minus the $40,000 platform, I mean, what is that, 0.6 of a full-time equivalent burdened employee? I mean, my point
yes, there's
is,
a burden. It depends what employees are involved, but yes.
My point is the average employee at the city that we're going to hire,
I see.
fully burdened.
Yeah.
I think we're certainly, this isn't a money-making opportunity. I think people need to be clear on that.
Yeah, but not by any means. No, and I do worry about the unintended staff cost, other cost. I mean, who knows? But that's why this is a pilot. And remember, there have been other cities that have tried this and decided to roll it back and get out of the short-term rental business. So there will be a lot of flexibility, and we will do our level best to document what the impacts are and report back to City Council.
Okay, I'm going to turn it over to Chris and then Carol, because he was next. Carol, and hopefully I've addressed 4 of the 34, and you only have 30 questions left.
I make no promises. In terms of people applying for permits, are there a criteria of past performance that will weigh in on this? So if you are a previous offender for whether it's social host or loud and unruly or contributed delinquency, any of these sorts of things, is there anything that when that person shows up at the permit office, we say that they are disqualified, or would that even be legal?
There is nothing, well, there are criteria that they have to meet to qualify, but they don't take into account any past bad acts, if you will.
Could we? Is that legal?
Potentially, if there's some nexus between that conduct and what we're looking to regulate here, and in this case, that would really just be one property owner at the moment. And that property owner is under a court order and some other issues at the moment, which probably are a better deterrent than what we could do by regulation.
Well, I think you can make a pretty broad argument that there's a very small number of participants in this that are the reason we're here. So I bring it up that the last thing we would want is to legitimize their behaviors by creating a program that they've necessitated.
I understand, but there are limitations, yes, on what we can do. And again, we could spend a lot of time crafting language, and I would want to look at our ability to further regulate people, or what a court might consider punish when they've already been through that process.
Secondly, and this goes back to the creating a right that I asked before, is there a way that in the permits themselves we can make explicit that this program, barring any action, comes to an end? Because what we would not want is to be sitting here in November of next year with a series of the variable competing sob stories, with someone telling us how they bought a house with the expectation that the only way they're going to pay the mortgage is by having a short-term rental, and now, we are all Ebenezer Scrooges for taking that away. And I think if we start something like this, it is incumbent on us to make clear that it is not in any way an assurance of an ongoing stream of revenue. Is that something that is within? Because I think we need people to be ready for that, because you can see, I mean, we can see that script being written.
We've already contemplated that, and the intention was, as part of the application, to provide language making it very clear, big bold type print, so that people are on notice that this is not a permanent program, and that this may very well, in fact, they should understand that they have no reason to rely upon this in the long term.
And are we legally, talking to the speed of enforcement, which is an incredibly sensitive question given the enduring misery that some of our residents have lived with, are there state mandated guidelines about how long the different thresholds have to be before enforcement actions can occur? I mean, can we show up on one day with a $2,500 fine and the next day with a $5,000 fine, or 12 hours later?
We can. A court, if we got to the next step, might not appreciate us being quite that quick, but it depends on the circumstances, but I think one of the issues we've had, I mean, it's a matter of public record now at this point. I mean, when we prosecuted the problematic property that we had, court dates get set, they get continued. People have reasons to ask for continuances, and it goes on and on. One of the individuals didn't show up, and I don't wish this upon anybody, but they were incarcerated for, I think, 48 hours for not showing up. And so, you know, the court system is not fast, but the criminal court system, if you don't follow the rules, there are penalties for that. But
What do we
but
do
it
if-
is faster than the civil system, I will say that, but it's not speedy necessarily.
But what do we do if they've had their 2 strikes and we say you cannot rent anymore, and then we're serving the citations and they just keep renting it? What's our recourse?
To file a criminal misdemeanor action.
We just keep doing that and then,
Well, the difficulty is the criminal process is faster, and it doesn't seem like, but it's actually in a way a little more humane because, because it is faster. The civil process can take years, and so both sides get very frustrated. It's more expensive legally, and it takes longer, whereas the criminal process will happen usually within 6 months, sometimes 9. But the civil process could drag on for 2 or 3 years.
last question, this is for Greg. I know that some communities we address Paso Robles, I think Hermosa does this as well. I know there was a logic behind not making people who are having a short-term rental have a placard, and I think it's largely aesthetic and to try and minimize the disruption in neighborhoods. I don't know if there's really a question there. I know that you all weighed that very heavily, but I think for council discussion, there's some other communities that when you have the short-term rental on the door, there has to be a sign that says effectively, it's short-term rental, and here's the number to call if you have concerns. And that gives you both the property manager number and the number for whomever the enforcing agency is, whether it's a code enforcement or it's a direct police line. That is something that we currently don't do largely for aesthetics and to minimize community disruption. There's obviously a creative tension there about, minimizing the police power that neighbors have to absorb and disruption of the neighborhood versus the ability to say, I need action now. I guess that's all I've got.
You still have about 27 to go by my count.
Those are all subordinate clauses. I was just run on sentences. Misuse of a semicolon.
Chris, on that last one, the idea of the signage, I have seen that before. There was a suggestion about, I think Mrs. Bex brought it up about noticing surrounding neighbors. Would that get at the same thing, or do you think?
I mean, I think that problematically what we've heard is that the neighbors don't necessarily want to know. They just don't want to know at all. And I think it's one thing to have a recourse on the website, which is probably the thing that would get the most use. I suspect maybe in Hermosa, less so in Paso Robles, the density makes it easier to just open the door and see a placard right there, just because of the way those lots are laid out. But it is something that in terms of responsiveness, something to let people know this is going on in your neighborhood. I suspect most of us, because there are 80-odd, we suspect rentals going on, don't realize how many there are around us. And so maybe it's something that isn't necessarily applicable to us. I just thought I'd put it out there.
Okay, I know Mayor Pro Tem had some comments. Thank you, Chris.
So one of the things we talked about originally was, what are our neighbors doing? And when we first brought this up, you were going to come back and give us what our neighbors are doing and some of their successes. What other towns in our South Bay are offering short-term rentals, and what are their success stories? And then the second question is, if today we don't have anything, so people are running them, at some point we just have to make some decision, because we either have to ban them or we have to put a permit, because at this juncture they're just kind of free for all, correct?
Well, they're technically not permitted, but we're not enforcing right now.
Okay. So today they're not really supposed to be happening, but they're just happening.
Right.
Regardless.
Well, yeah. Things that are not explicitly listed in the zoning code as a permitted use or an accessory use are generally not permitted. But this is a case where we are working on a possible permit system. In that case, it doesn't make sense to shut them all down right now. We don't really have the resources in terms of code enforcement to do that. So they're kind of in a limbo.
I would say we have a complaint-based code enforcement program. And so with regard to those properties that we do get complaints about, we do follow up, but it's only been a handful that have had issues.
But that brings another point. You're saying we don't have the resources today to handle the complaints. So if we do if we do say we ban it, are we gonna hire somebody? What's the plan to enforce then?
If there's a ban, we will certainly still request the $40,000 to use for hiring a company to monitor on our behalf. Their quote may go up because there'll be more activity possibly. And I believe we'd probably have to come back with a request for another supplement to that to cover staff time.
So then, back to my original question is, what are our neighboring towns doing, and what are their successes or shortfalls?
Yeah, I'm sorry that I didn't, I wasn't the one doing that research, and I forgot to get a response from that staff person. But I know that there was a ban in Manhattan Beach. I know that Hermosa Beach, for the most part, has a ban. And I'm not sure about Redondo Beach. Going the other way, Hawthorne has no regulations on this. And then LA allows them with a system of permits.
So we would be the only South Bay town?
Well,
in
I know that certain, most of the peninsula, if not all of them, have also banned it. I don't know the status of Torrance, though. And that's why I hesitate.
Before you go past that question, do you have any knowledge of, in those towns, it's still by right that someone can rent their home out for 30 days, correct? I mean, R1 zone right now states that I could
You mean
rent.
at least 30 days or longer?
Yeah,
Yeah,
30
that's-
days or longer, but I mean, you could rent your home to someone on a month-to-month basis.
Yes, you can.
And so, one of the things that we had discussed up here before was in the towns where it's banned, people sign a 30-day lease,
Yep.
collect the weekend rent, tear up the lease. And so it ends up being where it's just a loophole. It's like, well, I have a lease. They paid me. You know, it may be a weekend rate for those 30 days, but, you know, yeah. Sorry, go back, Carol.
No, that's fine. It was just. And then, as far as collecting the fines, the last question, we had talked about if they say they're not paying the fines and we keep assessing them, can we put a lien on the property?
Yes, ultimately. I mean, it takes a process, but yes, there's a process to lien property.
Mayor Pro Tem, is that it?
Yes.
Thank you. All right, Mr. Nickel.
My question goes to this concept of it being a primary residence and, you know, the loophole of someone getting their mail there, but they technically don't live there. If we limited the number of days, right, or I would even say the number of weeks that a property could be short-term rented. And now I'm not talking about the home sharing situations.
I understand.
Because I feel like we're talking about one thing when we're really talking about two completely different things.
Yes.
You know, the home sharers who live there and they're renting out a room inside the house and are very respectful of their neighbors know them, can call them, they can correct the issue immediately. You know, that's different than the party house. And, you know, with SoFi Stadium coming online and that concern of, hey, it's a party every weekend. And so if we think like, okay, we're going to limit the number of days, like the whole half year minus a day. If we do that, well, they're only renting it out on the weekend. You know, so it's going to be hard for them. They could rent it out every weekend and almost hit that half year day rate, right? Whereas
If that was the threshold, yes.
if that was the threshold. Whereas if we were wise about this and said like, okay, a short-term rental can only be rented out, you know, like when it comes to an entire home, because this is my biggest fear in this, is this pilot program is going to run out and we're going to have the exact same people in this room with the exact same complaints. You know, the home share is saying, look, my neighbors love me. Look, I have people that are telling me how wonderful it is to stay here and I'm a member of the community. And then you have the people that are like, there is a party in my backyard every single weekend, you know, one way or another. Like it's an entire house. The people don't live there. They've never lived there. And so I don't know if we can segment this in a way where it's when you talk about when it's in the case of renting out an entire home, if we treat that completely different than when people are renting out a room within their home.
The easy distinction is between a home share situation where the host stays on the property simultaneously with the guests versus when the host is absent.
Because I know we have plenty of definitions in this ordinance.
But that would be the logical distinction if you're heading down this path. The only hesitation I would offer is it would be difficult for us to enforce. It would be difficult to count the days. And even if we went by comparing it to the tax that's collected, it may not be the easiest thing to
But if there's 52
control.
weeks in a year,
Yeah.
right? Simple math, right? You do half it, you do half that. It's really, you can't do
Yeah.
quite half, but
Yeah.
you assume half, and then we're getting quarterly reports from Airbnb or whoever else for TOT purposes.
Yeah.
We're gonna know what dates
Yeah.
there was tenancy.
I'm just fearful that that might encourage the use of other platforms.
But are we
Just
not?
to escape the detection through that process. Obviously, when you have Airbnb and the at least 3 sites that are owned by Expedia, you'll capture the vast majority of the marketplace. But there's hundreds of other platforms, and if somebody were determined to, game the system, they could direct the potential tenants to go to another platform, and that would be to our disadvantage. So I think we should not write into this ordinance regulations that will encourage that. We want people to comply. We want to make it easy, and we want to make it as reasonably inexpensive as possible. But I think that the key is not to create an incentive for them to try to trick us.
Yeah, I guess I'm thinking I can respect that perspective. I'm just looking at it from the other side.
Yeah, absolutely.
As if this was happening in my backyard,
Yep.
how I would feel about it, and how I wouldn't want to have to be the policing agent.
Yeah, and my response would be that if we drive them into other platforms, you still have that problem. So what we need to do is open a code enforcement investigation on that. If it's a problem, it's a problem, whether it happens 26 weekends or 52 weekends. It can be a problem in one weekend to get that ball started on the enforcement. And if it occurs 2 or 3, disturbing weekends, then we have enough to start the citations and possibly go to prosecution.
True, but I want to say it was a planning commission a few years ago.
Mm-hmm.
We did a bunch of arithmetic, and we talked about, if you really want to go after someone who is looking to just make money off of their property, despite what it creates for their neighbors, well, then you go after how profitable can they be. And when you set limitations and you set caps, you are creating a hard ceiling for how much money they can technically make off of that property, in turn disincentivizing them to rent it short term, and in lieu incentivizing them to rent it long term.
Yeah.
Right? I fear that, again, we're going to fast forward, we're going to be in a meeting in late 2021 or early 2022 talking about this, and it's not going to solve the problem. We're trying to regulate based upon really like 2 bad actors.
Yeah.
Scott, one idea could be we're talking about the end of the sunset period. This thing sunsets, and I think they're proposing December 31st of 2021.
Yes.
If it goes live in July, could we not have a review in September? No, 2 months in. How is it going?
We can make a report. We won't have conclusive data there, but every month that goes by, we'll get better data, and we can make occasional reports.
I would think, given how sensitive this is, we would want updates
Okay.
every other month, I
Yeah.
would think, in the short term at least, number of complaints, if any, number of citations, all those things, because while the neighbors don't want to report, I fully understand that. I think all it takes is one bad weekend, like Mr. Pimentel suggested. I'm calling Airbnb or I'm calling the city. It's a 24-hour tip line. Police are out there. Yes, this is outside the allowance in terms of noise, and you got to stop that. And so I think it will be managed because of the systems we put in place. I'm less fearful about that. I do like the idea of somehow limiting the whole house. I just think, to Greg's point, it would be tough to manage. I'm wondering, VRBO, who owns VRBO?
Expedia.
Expedia and Booking.com and.
I know they own HomeAway also, but I don't know
Okay.
the others. I'm sure there's.
Okay. Continue, Scott.
I
Yeah.
don't have any more questions, just comments for us. Thanks, Greg.
Then in response to your comments, I would say this is the reason why this is pilot program. if these kind of problems appear to be unsolvable by the end of the pilot program, that will inform your actions, I think.
Yeah, and I guess my fear then, just to respond to that, is those who are not the bad actors.
Right.
I live in a fantasy world. Let's just put it out there. I live in this fantasy world where the home sharers that are doing this right should be allowed to do this right and be good neighbors.
Yes.
You know, but I was elected to protect the people that are sitting up on Christmas Eve concerned about what's going on. You know, and so, you know, we're between a rock and a hard place here, and I'm reading this, and all I'm seeing is that this is great, but I honestly don't believe at the end of this that I'm going to see success for the good actors. You know, that's my fear.
Yeah,
because the bad actors don't live here, and they don't care.
Well, those that don't live here, and this is not their primary residence, will no longer be legally permitted to do this.
Oh, okay.
And
so
if they do
the
it
home,
otherwise,
there's
then,
a home on California Street.
Mhm.
Okay, home on California Street that Gino, who is not here tonight, he lives near. They're traveling the world in an RV
I'm aware of this one, yeah.
because their boat got damaged
Yeah.
because they were going to travel the world in their boat, but it's their primary residence.
Yes.
You know, so they're not here.
Right, that would be hopefully a rare occasion.
But if that rare
happens,
occasion,
well, if they're creating problems, if we receive complaints, we will investigate and we'll start the process of citations and then prosecution. So hopefully by the end of the pilot period, we're not, you know, simultaneously prosecuting 5 or 6. I mean, most of them should be done by then because they'll probably be identified early in the process.
thanks, Craig.
Okay.
Okay. Any other council discussion? Chris?
I mean, I think I would reinforce the fact that failure or success criteria needs to be pretty clear. And with that, I would advocate wording for an early out. So at any point in there, we can say, look, this is doing exactly what our worst concern is for some of these neighborhoods. I would like to see the definition of overnight lodging tightened a bit. I think it's South Lake Tahoe that has a pretty clear no guests at all period. So if you are not on the list of a renter who is spending the night, you can't be there. Now they have some other quirky things about street parking and things that are particularly harsh. But I think at minimum, one of the things that we should seek to minimize the impact on neighbors is things that do not rise to the level of criminal conduct. That's not allowed in an unruly party. It is just noisome and an overuse of the property. That's a really difficult needle to thread, but I think one way to try and get to that is to say, look, you just can't have guests. If you are renting to sleep there, you cannot have guests. You have to meet them somewhere else. I'm extremely amenable to the idea of figuring out the home share piece, but I'm sensitive to the fact that I don't know that that's enforceable with the tools that we have. If there was a way to find a way to list out a qualification base, and I guess, or a disqualification basis from the permitting process, it doesn't sound like that's tenable though, so I will take that off my list, I suspect. And then the strong timelines for when people have to go. If we say this thing goes live on July 1st and our monitoring platform scrapes the internet and says, here's the 95 renting sites, then on July 2nd, a letter goes out and it says you've got till July 10th or 11th to come and get a permit. And once you do that, the violation clock starts going. And I'm just spitballing those numbers. I leave that to some expertise here. But I would like to see those timelines enumerated and fairly rigid, because I suspect the first thing to happen is that we will find a large number of those are people who will not qualify for the permits. So if we send them out to 95, a significant amount will be people who do not have a primary residence in that home and will not be able to rent it. So I suspect that list of 85 would go to 40 very quickly. So I think that would be sort of my wish list for modifications of this. And Greg, I appreciate you being my punching bag for this. Thank you for the Ed McMahon quality performance on that.
Chris, can I
Didn't mean
almost
to throw
summarize it?
bricks at
Because
you.
I like where you're headed with that, and see if our colleagues feel the same way. But I heard you say success criteria is certainly failure criteria as well. Early out clause, so that if we think this thing is going sideways, you can cancel it before the sunset date. Defining some kind of no guest provision, or at least having some reasonable allowance for a number of guests or something, some definition around that. And then once the notice period goes out, there's a time, the clock starts ticking, they have X number of days to get their application in. Is that-
And the clear piece on the permit itself that says, look, this thing ends on December 31st. Please, 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 if you are buying a house here, do not buy it on the presupposition that you will have this right ad infinitum.
Do my colleagues feel the same way?
Yeah, and I just think add the last piece about the clarification on the child.
Yes, the children definition. I think that you guys are going to put that in the ops manual. Do you see, Greg, most of the items that we just enumerated being part of the ops manual or part of the ordinance itself?
Can I also on that, on the early out, I think definitely needs to be in the ordinance. And since we have called out how we're going to identify who's eligible, at least on, if we're going to say no overnight or no guests, that should be in the ordinance also. The children one, whether we put that in the ordinance or in some regulations, but just from a legal perspective, the no guests and the early out, I think should be in the ordinance.
And then do we want to put any type of limit on the number of permits we issue? And then every year it's a random draw on who gets the permits?
I don't think we should do that during the pilot period myself. I think we'll learn a lot from that. I think Chris is right that some will drop off because they won't qualify, but we can get back to it one second. I just want to clarify one thing. If we're going to put that in the ordinance, which is before us tonight, Mark, on the guests, I think we got to drill down a little bit on that as a council. I mean, we saying no guests, like, I have my family in town and I'm in El Segundo and I happen to know the Pimentels and I want to have Chris and Laura over for a cocktail and I can't do that now. I mean, how restrictive do we really want to be on that?
I wouldn't do that.
I think we got to be careful with, it should be reasonable. I don't know how we define that, if it's a ratio of number
The
of
hard part
people.
about that, it really is one of the single biggest things when we talk to people. I know that it was said at the podium that people only talk to hosts. Well, I said we get an earful from everybody. And one of the biggest complaints is raining on somebody's birthday party, right? You are next to a house that's being treated as a venue, and it's a child's birthday party, and how are you the one who is calling the police on a child's birthday party because you're just sick of it being a child's birthday party every Saturday and Sunday, every weekend of a year? In 104 days of clapping and singing happy birthday will drive anybody crazy. So I think that when we talk gatherings and reasonableness, like if you send a poor code enforcement person out there who sees a bunch of happy kids around blowing out candles, who's going to say that's unreasonable? Of course it's not unreasonable, right? It's kids having a birthday party. But the fact is that is an inconvenience and nuisance to neighbors because it happens every single weekend. So I think that we really do have to be declarative on what this. So if we want to say, look, you can have 2 guests or 4 guests or 6 guests, I guess that's our prerogative to put in the code. But I do think we have to put something in there because reasonableness in a snapshot on time for a code enforcement officer is not reasonableness to neighbors who are dealing with it every weekend.
Usually, in my experience, when you rent an Airbnb, in a lot of cases, there's a contract, either hard copy or electronically, that stipulates you're being charged by the number of guests, and I think also probably whatever the current ordinance is restricts that number, and you're confirming or assuring that that is the number of people you'll have on board. I just think number of guests, how are we ever going to enforce that unless there's an issue? And if the issue is, to your point, they call because it's a loud birthday party, I think first and foremost, maybe Chief can chime in here, I think it's usually noise is the first consideration. Is there a noise nuisance? Maybe not. And if the noise elevates, even though a police officer doesn't want to be the bad guy, they're probably going to say, you got to tone down that piñata beating. Can you touch on this, Chief? Because we're trying to figure out, I think we're struggling with how to make this practical for code enforcement and police officers.
When it comes to noise, Mayor and Council, there's different levels. So disturbing the peace, that can occur at any time of the day, and there's no decibel level. If your neighbor's having a party and you feel your peace is disturbed, you can call the police department and we can come out and ask we talk to the neighbor, try to intervene, tell them, hey, your neighbor called, you're disturbing the peace. Ultimately, that would be up to the person calling if they wanted to effect a citizen's arrest for the violation. The person who is the violator would get a citation, and the two parties would go to court and hash it out. So that's one avenue. For ongoing occurrences, things which we've experienced over the last couple of years here, we have the loud and unruly gathering ordinance. That's usually not a first-time offense where my neighbor's having a piñata party and I call the police, so now I want a loud and unruly gathering. That is more a tool for ongoing problem areas, not just your one-off parties. We have noise or the disturbing the peace section that deals with that. Did that answer your question?
Yeah, I guess one of your officers, a code enforcement, shows up to a complaint. Again, it's this birthday party. It's clearly an Airbnb or short-term rental. They show up. What is the easiest factor to hone in on, like to enforce? Is it number of guests? Your permit says you're only allowed 8. Clearly there's 15 here. That's a problem. Is it somebody saying it's disturbing the peace and it's a noise factor? What would make it easiest for code enforcement and your department to enforce?
I don't necessarily want to speak for code enforcement. When you have an actual number, you can only have this many people at a gathering. I think that's very problematic to enforce because I think that occurs on a daily basis throughout this community, and what's good for one and not the other. But from their standpoint, I'll let them speak to it. But yes, if you look and say, by the terms of this Airbnb, you're only allowed to have this, you clearly have more, it's a violation, and it follows whatever due process ensues through the code enforcement process with that. With disturbing the peace, it's really, we have to take a step back. It's not our peace that's disturbed. It's you as a citizen who's being disturbed by this. And so that's your call with that. And typically in those we try to mediate. We typically try to avoid an arrest and a crime report because that's not really the best outcome for that. So we would try to talk to the people, try to explain to them the conduct that's occurring, try to talk to the people calling and trying to, I don't want to say talk about what's reasonable, because if that's the 52nd week in a row where this is going on, that could be completely, in their minds, unreasonable what's occurring. And they've just had it, straw that broke the camel's back, and they want, nope, absolutely, I want that person arrested, whoever's throwing a party over there. And in which case, we would take a report, issue a citation, perhaps, or just take the report and send it to the DA's office for consideration. And that happens very, very infrequently.
Okay. Thanks, Chief. Scott or Greg, do you have a thought based on what we're trying to get to here with Chris's original idea and either number of guests or?
I don't think that I have a solution for that yet, but I think one is possible. And it's probably related to frequency more than the number of guests. So if we could define daytime activity that is associated with a short-term rental occurring on a frequent basis, or even a very infrequent basis, or at all, I think that would be the better approach rather than counting up the guests. But I would like to, contemplate that for a while before I commit.
Okay, bless you.
Well, as it's written now, it says lodging only.
Yeah.
Right, so, I mean, we identify when someone rents who's lodging there. If there's 5 people lodging there and somebody says there's 12 people over there, then that would seem to be a clear contravention of the
reason
code.
I'm concerned about that is if someone, say, rents it for the whole weekend to celebrate their child's birthday, does that mean they can only have the party at night? See, they could have the birthday party in the day, but they're legitimately staying there because they've rented it for the nights. So I think that we probably ought to pin it on frequency, and if it happens more than twice or something, then it's a violation.
Mark, I see you contemplating over there.
Well, yes. Well, first, again, the early out, that's relatively simple language. The guest thing, the contracts you speak of, when I travel, usually like Hawaii, I mean, you sign one of those contracts, you have to, not only have to identify a number of people, you have to put their names and, there's all these warnings, you go over, it's $100 a person, you lose your deposit, they kick you out. So I look at that and go, I spent a lot of money on this trip. I don't want to lose my, my vacation. So those things worry me. I don't know that the average person cares about that, but I do. But from our perspective as a city, that doesn't give us any enforcement rights. That's just between the landlord or the owner and the occupant. It would be difficult. Nothing will be easy, and I don't see. Based upon a birthday party, none of us want to be in front of a court arguing about a birthday party. I'm certain of that. If it's based upon the number of days or number of guests, and I'm going to disagree a bit here with the chief and Greg, at least then that's just based upon a numeric issue, not based upon the qualitative. I don't want to be talking about children's birthday parties, elderly people's birthday parties, anybody's birthday party, because I don't think that that's going to be, as far as enforcement purposes, a court's not going to like that. They're going to want to see something objective. And so whatever the council wants to do, I would focus on something objective, because it's really hard to enforce anything subjective.
You have a recommendation?
I would perhaps, if we're going to add language to this along those lines, we're going to need to go back in any event and add that language. It needs to be in when this is introduced, and perhaps we need to look at, and you said the no guest language I hadn't seen before. Maybe we need to spend a few days looking at a few cities and talk to them about real life. Does that work? Because it's one thing for us to put language in, but if there's cities that actually have that language, and call them and talk to them and say, okay, what do you do with this? Because we can put all sorts of language in it, but see whether reality actually, if that works. And we could come back at the next meeting, and this could still be introduced at the next meeting, second read, and this could be effect so that we could still make the July 1 deadline. And we would love to get this done tonight and move on, but we want to get it right. So would the council prefer us to go do a little more research on that particular issue?
Well, so you're saying we could still introduce the ordinance, make a slight refinement to it before the second reading, or would we have to do the first reading?
We have to do the first reading over again. So other than to draft language on the early out, which I could do sitting here, any language on guests I think is going to take a little more thought and potential little more research, so we could come back and give that to you. I know no one's anxious to keep revisiting this, but if we're really going to add language on guests, I think that's going to take a little more work.
Let me ask you another question. If we introduce this ordinance, we move forward through the process, and then we've determined that there is some other consideration we need to add, be it guests, be it whatever, can we introduce to amend?
We could amend it, yes.
Okay.
So we could put in if the council wants to do the early out language, we could do that tonight. You could introduce it. You could adopt it the next time. And if you want us to then look at other options on guests and whatnot, we could come back and amend it again.
Does that amendment require a first reading and second reading?
Yes.
I thought you said there was 2 items that you wanted in the language.
Early out clause, no guests, time frame until XXX to get the permit done once we've given notice. Clear language. Chris, remind me what that was again.
The clear language that this program without action
Oh.
is going to end on December
Sunsets,
31st.
right, on the permit itself, right?
And then
The time frame, sorry, the last point, that is language that will go in the application that we could put in the regulations that Mr. McLean's referred to, and the point prior to that, which I've now just lost.
Time frame, once we give people notice from July 1. they
That
have X.
also could be in the regulations as opposed to the ordinance. I mean, so that we could bring back as part of.
So for now, the only change of the ordinance would be the early out clause language, which you would, I would imagine, or you'd read some language tonight as you introduce the ordinance.
So
Okay.
what I did look up, like Lake Tahoe, what they've done is they put a max of 12 people. So what we could put in there, a maximum of people that are allowed per each short-term rental, just to start the process of putting a control.
That's
Is
interesting.
that Lake Tahoe or South Lake Tahoe?
Well,
I would just, the reason I don't want to continue to harp too much on it is just that I think it's so important, because when we talk about the
South
two
Lake
sort of things that really motivate people to bring this here, one of which we addressed with a series of party ordinances, but the second one is the death by 1,000 cuts that is occurring on California.
Yeah.
So let's put a max of number 50. I mean, you can pick a number, you know.
Yeah. We could always amend that, right?
Yeah.
Yes, that, I mean, if you want to agree on a number tonight, we could add that pretty simply this evening. If you just want to say no more than X people will be on the premises at any time, we can add that. In fact, if you just put that number, then that sentence I just said will work.
Yeah.
I mean, would I be crazy to suggest that we just don't allow an entire house to be rented short-term? That you can only rent bedrooms, a maximum of 2? I mean, then a 2-bedroom house could essentially be rented out completely, but that we just exclude like whole house rentals from the short-term rental option. Then you avoid the party. You include the home sharers.
So I want to go to the Tokyo Olympics this year, and I want to rent my house out for 21 days, just as an example. You're going to prevent me from doing that, and every other homeowner in El Segundo?
It would, yeah.
What about the 2028 Olympics? You're going to prevent
Well,
me
that's
from when it's
the-
here as well? Yeah, I don't support that. I don't think that we should do that. I think that there are plenty of people that are doing it. I mean, when I knocked on doors in 2016, I don't know what Carol's experience was, but I heard from plenty of people who are responsible home providers that maybe live in the back unit, which might not be allowed if it's considered ADU and not an R2, that are renting out their front home, that are leaving for periods of time, renting out their entire home. So, I mean, you think about like where I want to be in 15 years from now. I want to be traveling as much as possible, coming back to my home base, but being able to utilize that asset a little bit. I think a lot of people that I spoke to want to do the same kind of thing. So I wouldn't be supportive of cutting out that flexibility out for people. I believe that people that buy property have a right. I also believe that, I mean, I live 2 blocks from where the party house was, walk my dog down that street almost every day. I understand the concerns. I think we're addressing many of those concerns, and I think staff's done a great job of continuing to work on this and hearing from the public over a long period of time. But I'd certainly entertain my colleagues on Scott's notion.
Okay, so I'm going to put a max of 12 people. That's 6 couples.
Chris?
That's 12 renters, or 12
Max
12
it-
renters. Or 12 renters and guests.
Yeah.
Total, yeah, just 12 people at any given time, I think is what you're saying.
But if it doesn't work, we amend it.
Yeah.
I can
Or
get
kill
behind that.
Okay, so then that language that I read will insert the number 12 and include that in the ordinance. And then on section 4-15-14, that would be amended to read, this chapter shall remain in effect until the earlier of this ordinance being rescinded or
December 31st.
December 31st, 2021.
Yes.
And then the other points about the time frame by which to get your application in, the clear language on the application that this is a sunset and could expire. And are we still defining children?
We'll come back with the
Okay,
regulations.
so that'll all be in the ops manual,
And
right
we'll
there.
actually come back also, I think, with the application so that the council will see what the applicants will sign and be acknowledging as far as what their rights are and what their rights aren't. So,
Okay, any other thoughts before we turn it over to Mark to read the ordinance?
I just had to have one question. I know I mentioned 12, but do we want to make that 12 adults or just 12 period?
Period.
Yeah, I concur, period.
yes, well, I mean, that's a policy call, so
12 people.
Yeah,
12
12.
people. Okay. All right, so then with that and those revisions, an ordinance of the City of El Segundo amending Title IV, Business Regulations and Licensing of the El Segundo Municipal Code by adding a new chapter establishing regulations for short-term rentals and amending Title 15, Zoning Regulations of the El Segundo Municipal Code, allowing the operation of short-term rentals in the city's residential zones through a short-term rental unit permit process is ready for introduction.
We'll introduce. I'll introduce, since there are no
This will-
takers.
Then this will be brought back at the city council's regular meeting of February 18th for potential second reading and adoption.
Thank you.
Will we have the manual, but for the
good
second
question.
reading?
When do you expect
With
the
the
manual
timelines
to
and
be
things?
produced, Greg?
There's a number of things that we have to address in the ordinance and to consider here. I would like the opportunity to reformat the ordinance, for example, but I think that the manual could be done very shortly after, but it won't be ready for the next one.
30 days, you think?
Yeah,
or-
something like that.
Do you think maybe just the key elements that we could report out on some of the key elements on here before we move to adoption? Just so some of the, like the timelines and the metrics and those sorts of things.
I was taking notes. I think I caught all of them.
Suc- Basically, success criteria and failure.
Yeah.
But he's just asking, could we get that within 30 to 45 days before?
Yeah.
Okay.
All of that would be covered either on the application itself or in the manual or both.
Actually, you wanted that before February 18th, aren't you, Chris? Ideally.
If possible. I mean, it doesn't have to look beautiful, just so we know we fully know what we're moving ahead with.
So like the time frame, they have X number of days before to get their application, and once they've been noticed, and the definition on children. It looks like those are really the only ones left, I think. Right?
Yeah.
Does that seem feasible, Greg?
I think so.
Before the 18th? Okay.
Yeah.
Thank you for all your work on this, Greg, and Sam, and everybody else. Much appreciated.
Thank you to the public for coming.
Yeah, and thank you for the public. Thank you. Even if you didn't like what you hear, but thank you for your input over all these years. We appreciate it. That concludes item number 4. We're on to D, staff presentations. We're going to go out of order a little bit, Mr. Mitnick, are we not, with item 8, which relates to Smoky Hollow Plan. I'm going to recuse myself as I have a current project there. All right, we're going to reconvene at 8:05.
Thank you so much, everybody. Thank you for coming. Can Mr. Mitnick, is Scott, Mr. Mitnick around? Calling Mr. Mitnick. Call it paging Mr. Mitnick.
I mean, Barbara's here. We can just have her as acting.
Yeah, yeah. So,
The mic's hot.
is he coming? There you go. All right. All right, we're going to get started. We're going to start, as Mr. Boyles indicated, we're going to start Section D. We're going to move up item number 8, approval of new process to evaluate proposed developments and the community benefit plans, public improvements and conditions to be provided by developers in the Smoky Hollow Specific Plan area in exchange for additional development rights prior to the consideration by Planning Commission and City Council. I believe Mr. McLean is going to be presenting. Not that he hasn't been up here all night.
Yeah. Well, this one's twice as long as the last one, so brace yourself. I'll try to do it quickly, though. So this is the community benefits plan process. The benefits plan is one of those features of the Smoky Hollow Specific Plan that was written into that plan, and this is how staff intends to make it happen. So let's start. This is language directly from the specific plan. It says, in exchange for allowing incremental increases in development intensity, the community should, in return, receive certain benefits. So this functions differently than an adjustment or a variance or something like that, where you just evaluate it and say yes or no. This one requires that the community gets something in exchange. So my objectives on this presentation today, and in the process of developing this, was to develop a process that allows us to be objective in our recommendations. And you'll see this is a little bit tricky for this because of the language in the specific plan. We also want to be able to assure the Planning Commission and the City Council that the findings that are necessary to approve a project can be made. We also want to provide guidance to developers, architects, and owners, so our process will be publicly available. And lastly, this one is a little tricky, but we want to avoid unintentionally enforcing conformity. We don't want everybody to build the same thing because it worked somewhere else. So this process will allow for maximum creativity. So let me start by saying that there's 2 tiers of community benefits outlined in the specific plan. It's easy to define tier 1 as anything that's not tier 2, so I'll define tier 2. Anytime the plan involves a building height over 50 feet, or, well, actually, it applies when it's 35 too, because there's a in-between state that wasn't addressed, but it was pursuant to the adoption language. And anytime there's an FAR over 1.5, or if there's 3 deviations from other standards, or any combination thereof, that's a tier 2. That would be approved by the City Council upon recommendation of the Planning Commission. Everything else is a tier 1, it stops at the Planning Commission. So there's findings to be made for a tier 1. So the first is that it cannot be detrimental to the public health, safety, and welfare. That's a common finding that we find in most of our approvals. Probably is somewhat subjective, but it's rare that something would rise to that level. So our response would be, if it's not egregiously obvious that it's detrimental to the public health, safety, or welfare, we're going to assume that it is not detrimental. And if there's any doubt or something falls on the fence, we'll err on the side of the applicant's benefit. The next one is that it has to be an exemplary project in its design, either in the project itself or the streetscape. Exemplary is the problem word here because it's going to be very difficult to be objective and make a recommendation on what's exemplary, but I'll tell you how we're going to do that in a bit. The next one is that the benefit has to directly implement objectives of the specific plan. So in order to make this happen, we devised a new worksheet. It looks like this. You have a copy of it in your plan. It's a little bit complicated, but it's actually quite simple. It's just a linear process through 5 steps, 3 for a tier 1. So let's take a segment. Step number 1, there's a finding. It says the proposed building height, intensity, or deviation from the development standards would not be detrimental to the public health, safety, welfare, or materially injurious to properties or improvements in the vicinity. Again, if it's not egregiously so, we're going to make that recommendation that you can make that finding. So that's one check. Okay. Next one, the proposed community benefit provides exemplary design. Now, this is the tricky one. So what we've done here is there's a worksheet, a second worksheet that has basically all of the, where is it? There. Oh, sorry, back up a bit. These are pages from the specific plan outlining the design guidelines. So we're going to use that. We put it into another worksheet, which you can see has a bunch of check boxes. There's 3 columns. There's a yes, no, and a not applicable. And each of the 32 examples that were in the design guidelines are listed here. Okay? And so what we've decided as an objective way of defining exemplary would be that a project must have at least half and then one more. And if it has that or more, then it's exemplary. That works out to 17 because there's 32 possible points to score there. So once this process is ratified, I guess, or blessed or whatever, it's just a matter of us ticking the boxes and counting it. There's no more subjectivity involved there. So we got to check on that one, say. Then we go to the third step. The proposed community benefit directly implements objectives of the specific plan. This one's actually fairly easy. The specific plan has objectives sprinkled throughout the text, and there's quite a few of them, and they're easy to find. So we would just count them up and see. We would offer that, well, here's 1 or 2 that it definitely meets. So if it meets all 3 of these and it's a tier 1, we would recommend to the Planning Commission that the findings can be made, and we recommend approval. The Planning Commission may use their judgment and decide to agree with us or modify it or otherwise have a different opinion. That's okay. This is just going to lead to our recommendation. So now let's look at tier 2. The first one up there is all the findings of tier 1. So a tier 2 project has to go through the same first 3 questions. And then I'm going to take the other ones out of order. The community benefits proposed do not principally benefit the project or occupants of the project, but rather benefit the community as a whole, or the Smoky Hollow area as a whole. That one is also a lot like the not detrimental to the public health, safety, and welfare. It's one of those things that should be obvious if you see it, and we'll make a recommendation based on that. So for example, if somebody is proposing some open space, but it turns out to be surrounded on all 4 sides by their building, and it's not easy for the public to know it's there or get to it, well, that's obviously not a benefit to the community so much as a benefit to their tenants. So that's the basis that will be used for judging that. The other one is that the value of the community benefits bear a relationship to the value generated by the project. This one's tricky because it says bears a relationship. It doesn't tell what that relationship should be. So I'm going to go into a process that we've developed in a bit to deal with that. So again, the first one, do not principally benefit the project or its occupants. Say we got that one. And then the last one, where we're talking about value, this one's a complicated one. This takes up half the sheet. But in reality, it's not that hard. This area here is where we will put the dollars that the applicant will actually spend to provide the benefits. And the way we derive this is by hiring a consultant that is an expert at these things. They receive the data from the applicant, so it would include information such as how big, if they have any construction estimates. They also have knowledge of typical costs for certain types of construction or landscaping and so forth. So they'll make a informed judgment on what the actual cost will be, because mind you, this is stuff that isn't provided yet. So that consultant, and we have a couple of them on board, will give us the numbers to fill in these. This is the cost to the developer. The next bit is what I call the discount factor. And the logic behind this is that the cost of providing a benefit is not the same as the value that the community incurs. So there's a discount. And I'm going to go through an example a little bit to show how that works. This is the complicated part. But nonetheless, if you take the dollar amount of the cost and multiply it by this equation or whatever, you're going to get a value that the community incurs of that cost. So let me, and the sum will go there. So let me run through an example. Let's say that there's architectural enhancements that will cost the developer an extra $500,000, okay? So that number appears here under Group A, which is architecture. And so this sums the cost of this column. And then what we're going to do is we're going to work through this formula. And the way that works, is start by looking at Group A, which is just the top group here. And there's 12 possible. We tally them up. How many yeses? Okay. In this example, I've given you 9. Okay. So then we start by noting there's 9, and we'll subtract half of all the possible. And the reason for that is that we don't feel that anybody should get full credit for the cost. The reason being that it would be too easy for someone to put all of their effort into one category and really skew the whole results. So they're not going to get credit for providing half of those benefits, but they'll get credit for anything above that. So in this case, it's 3. The point is, it results in a number that seems to be very reasonable for the community's value of that $500,000, which is $125,000. Okay, and that goes down here. That's the sum of this column. Okay, so now the next thing. This number is the added project value. So when they ask for additional height or additional FAR or other relief, that improves the value of their project. It improves the value of what's going to be built. So our consultant will also help to identify that. So if they gain another floor, for example, there's value in that. How much they can rent it for will determine how much it's worth. And they'll apply all of the standard equations that they use to calculate that, and they'll give us a number. And in this case, they say $1 million of additional value to that property is granted by whatever they asked for, height or FAR or whatever. They're going to spend $500,000 to get $1 million benefit. Okay. The community's assessment of that value is $125,000. So what we do is we simply take the community's value and divide it by the additional worth of their project, and in this case we get 12.5%. And what we've decided is that 30% will be the threshold that we'll use to recommend this finding being met. Okay, so in a case like this, let's say that they come back and they say, okay, we're going to put $200,000 into public infrastructure. Now, public infrastructure has a very generous factor here, 110%. So they're going to get $220,000 credit for $200,000 of expense. That totals up to $700,000 for them spent, still $1 million of value. That didn't change, but the community's sense of the value increases to $345,000. Okay, that hits the 30% and then a little bit more. So we would recommend approval. So it's a little bit convoluted, and there's a reason for all the numbers. But the important thing is that once we've decided on the process, it'll be exactly the same for everyone. And we will merely be counting the tick marks on the one worksheet and plugging in the dollar amounts on this worksheet, and we'll get an answer. Now, there's a couple things I want to emphasize. One is you'll see that the best possible amount of value that they can get from anything in these categories above here is half of what they spend. Okay, but for these down here, which is underground and utilities or public infrastructure, we feel that those are almost entirely the benefit, or the benefit goes almost entirely to the community, so they get a bonus value there. So there's a little bit of a built-in incentive to put your money there, and because we're discounting all of these by half right off the bat, a little bit of a disincentive unless you're going in that category hard. So what that promotes is much better attention to the details, much better quality when you're proposing something in one of these categories, and we feel that the outcome will be positive for Smoky Hollow. but also we're hoping to see some of the public infrastructure be funded or built through this process. So in this scenario, we would make a recommendation. Now, that goes to the Planning Commission, where they will make a recommendation to the City Council. And the decision on those Tier 2s will be made by the Council. And that's pursuant to the specific plan. So let's review the objectives again. Develop a process that is objective. Once it's adopted, everybody is treated basically the same through counts and adding and subtracting and multiplication and so forth. It becomes rather objective for us. There's very little left that would be subjective. In those cases, as I pointed out, it would only be in the extreme examples where we would have to use our judgment. We would also, through this process, be able to assure the Planning Commission and the City Council that the findings that are necessary to approve a project are made. It does not bound the either decision-making body to do that, but they can. And we also provide this, as I said, to the public. Anybody who wants to go through it can find it, and they can adjust their development plans accordingly. And then lastly, I want to emphasize that this process also does not stifle creativity, because we're not telling people where to put their efforts, but there's options, lots of options. And there's even options that are not listed that can be taken into consideration as well. So those are the 4 objectives met, and that's my presentation. There's a lot more behind this, and I'll be happy to go into great detail if you want, but the objective of how we're doing it and what we're trying to achieve was the main goal here.
Thank you, Greg.
I like that it adds a lot of clarity to people who are developing that. I have a bit of a tangential question. Can you be credited because we have that percent for arts program?
Good
does
question.
the other if you're in the other column and you develop a architectural piece that is fitting, can you credit that on both regards?
No, but you can still get credit for it. But the way that it works for any thing that is required otherwise by ordinance or by the zoning code, this also includes the number of bicycle parking spaces, for example. You will not get credit up to the requirement, but if you exceed that requirement, you will get credit. So let's say that for whatever reason, you're required to put $500,000 toward art, but you install something that you can demonstrate will cost probably $700,000, you get credit for the $200,000.
And conceivably on the infrastructure piece, if someone wanted to participate in making some of those streets one way as part of the specific plan, with that sort of funding, I suspect you would subtract out the in-lieu parking fee.
Well, no,
And then-
because the in-lieu parking it operates entirely separately.
So, but that wouldn't be like an obligation in the same way
Yes,
that
it's
the
an
artwood
obligation,
piece?
so they get no credit for that.
Yes, they wouldn't get credit for it, but the difference, if they said, look, they want to over-contribute because they want to provide extra parking on the street.
Well, yes, but it wouldn't be the in-lieu parking, because the in-lieu parking applies to the parking that's required on their property and not what's in the street. So they would get credit for the street work under the public infrastructure section, which is advantageous to them.
Got it. Nothing further on my end.
Yeah, I don't have any questions.
I just want to make one clarification. So the consultant who is determining the value, the
Yes.
added value, that's our consultant?
Absolutely, works for us. They will, this is one case where we will allow the consultant to speak to the applicant, but only because the applicant is the source of the information, and some of that is proprietary. We don't want it to necessarily get into the public record before it's decided. So the consultant can deal with them and get the data, if you will, without revealing too much to the public.
All right, and then what other cities use this type of model?
None that I know of. We invented it.
Oh, very nice.
Most cities would just simply do like a checklist, and if you hit enough checks, you're good. But then what happens with that is you end up encouraging a lot of conformity. You get a lot of the same thing, because if it works once, it'll work again. This has built-in factors that will prevent that in some cases. For example, if you were to propose a coffee shop, the amount of value that the community will incur is a factor of how far the next coffee shop is. If it's on the same block, you'll get almost none, but if it's a half mile away, you'll get all the credit, up to 20% I think we have for that. So this is a really more fine-tuned, and it's designed by us for our purposes, and I don't think anybody else would ever use it. It's awfully complicated in some ways.
And I just want to make sure, because it is subjective to this question to you, Mark, we're not opening ourselves up to any type of lawsuit of, we did over here, but didn't over there.
Well, that's the point of this exercise, is that the specific plan didn't provide enough objectivity. This provides more, and part of the reason for these going to the commission and the council, depending on the level of review, is to establish some objectivity in the process. They will, need to look at other decisions, and it may not be exactly equal, if you will, but the goal is to make sure that people are being treated objectively as equally as possible. And almost anything we do has some subjectivity to it, but this is to actually try to minimize that. So there's always a potential somebody could sue us, but this is actually to try to reduce that and to make this better for the applicants so they have a better understanding of what's expected.
Like anyone else, they can appeal to the planning commission and appeal up the chain, like with any other
Correct.
planning issue, I suspect, correct?
Yeah, or if they requested that or insisted that we take something to the planning commission without our recommendation, we'll do that as well. But then, in order to approve it, the planning commission would have to find a way to make the findings. And in that case, I'm not sure that they would have to be as objective. I think the planning commission's entitled to be subjective on that. So is the city council.
Well, good job, Greg.
Thank you.
Congratulations on coming up with a plan that, we're knock on wood, that should work pretty well. All right, so does anyone want to, do we need to take a vote?
Yes. There is I'm sorry, there's a resolution. This is ready for adoption. A resolution adopting and approving the methodology for approving Smoky Hollow Specific Plan community benefit plans is ready for adoption.
Who would like to introduce it?
I'll introduce it.
No, this is
Oh,
first,
no.
second, and
Okay.
vote.
Because then it also is recommending that we waive the second reading.
Is it?
It says recommended council action.
It's a resolution, so it's just, that's an error, and it's just adoption.
It's just
First,
vote to
second,
adopt.
and vote.
All right,
yeah.
I'm just trying to do as I'm told here.
No, that's a good catch. Apologize for the error.
So do we need to take a vote?
Yes.
I'll move to approve.
I'll second.
All in favor?
Aye.
All right, approved. Now we'll ask,
Welcome the mayor back.
we'll welcome Mr. Boyles back. Mayor Boyles? And
I'd
we'll-
say that we should send Scott to find him, but then we might lose Scott again.
Paging Mr. Boyles.
I hear him.
Here, he's coming.
Looking at the Olympic trials for Tokyo, apparently.
While we're waiting for him, so I recently switched from like DirecTV to YouTube TV, and YouTube TV has the Olympic channel. Game changer. My son is watching luge. Like, Michaela Schifrin is like his new. He just talks about her all the time. Dad, she's awesome. She's the best skier in the world. Like, where do you see this? You watching skeleton?
I'll have to talk to you about that.
Oh, you're watching on YouTube on your phone.
All right, we're going to move to item number 5, which is the FY 2018-2019 City Strategic Work Plan Year-End Report. Joe DeLilio, and back to Mr. Boyles. Oh.
Really?
Go ahead. Okay. As Barbara goes up to the mic, I'll make some introductory comments. The legislative platform that's proposed for you This has been a work in progress for quite some time, and I do want to stress that this will be a living document and process as we get this established. Okay, so with that, I'll turn it over to Barbara Voss, and she'll give you a brief overview.
Thank you. Good evening, Mayor Boyles, members of council. So this evening I bring before you a proposed legislative platform for the annual 2020 calendar year. The purpose of the legislative platform is to represent official city positions on proposed regional, state, and even federal legislation. What the platform will do is it will enable the city manager to respond quickly, take action quickly under the direction of city council on initiatives that impact the city and are being considered at either the regional level, state, or federal level. The platform, I want to thank, I should have started with this, but all of the directors and department heads. The platform is divided up into categories that roughly follow each of our departments, and their input and guidance on what should be included was invaluable to putting this together. So the areas are the city clerk, electoral process, community service, which covers rec and park and library, economic development, emergency management, environmental sustainability, fiscal and administrative, human resources, general government, planning, housing and land use, and public safety. So you'll see in your packet that we have items that the city either supports or opposes under each of those categories. In general, the focus of the platform is protecting local government control, maintaining local government revenue, pursuing public security funding, and obtaining funding for environmental sustainability, transportation, recreational, technology, and public infrastructure improvements. The city manager's office will, as Scott mentioned earlier in his introduction, will monitor proposed legislation, and things that are not contemplated within the legislative platform will be brought forward to city council for approval. Things that are within the purview of the platform we can take action on quickly, whether that be a letter of support or speaking at a meeting or whatever it might be. It'll be updated throughout the year to update and prioritize as things come up that we may not be aware of right now at this moment. It does not preclude city council from bringing up new items for us to support or oppose. It would just be a matter of bringing an amended legislative platform back to you with that item. And staff will do that. Staff will present the particular item. And then finally, I just wanted to mention that the legislative platform is aligned with the 5 strategic goals and supports these goals. And the purpose is really to help the city provide the highest level of service to residents and businesses. If you have specific questions.
I mean, I would say this. I think on the one hand, I am delighted we have this because typically we have been on the react and adjust sort of portion of dealing with state initiatives, and I think that this does a great deal to get us in front of it. On the other hand, I would say that this list is comprehensive almost to a fault, and that's not, I mean, that is not a fault, right? I mean, because it's overly comprehensive, some of these things are things that are items that we may have some diversity of thought or are somewhat terms of art. You know, net neutrality means different things to different people. You know, and lumping it next to the census, we all 3 of us sat through a lengthy census presentation. We're well armed to endorse items to get the census count, but there's some items on here that I would just recommend if everyone's had a look that says, look, this is something that I think we would rather deliberate a bit before we took a position on. So very helpfully, naturally, I have some of those. I presume, Mr. Mayor, you do as well.
Yeah, no, actually, I share the sentiment at lunch. My lunch meeting with Scott today, I shared the same thing. While I appreciate the comprehensive nature, you guys obviously collaborative, put a ton of work into it. There were some that struck me as, ooh, I don't know if we all agree on that one particular item. So I think we can get to that. I think this is a great framework. I agree with Councilman Pimentel that there have been things, even when we get, I mean, I sit in all those COG meetings and we've got people sit at the League of Cities, et cetera. We're getting legislative information, opposition, support, suggestions, but we're often kind of caught on our heels. So this is a great step forward in terms of becoming more proactive. So good work, yeah. Mayor Pro Tem.
So, as far as the list is to help us get ahead of it, so that means that we are going to be proactively watching for these things coming down the pike from the state of California and being proactively saying, hey, this is something that's important to the city, let's get ahead of it. So it's great having a list as long as we're actually acting upon the list.
Right.
It's very important. Like, those are two different things. I just want to make sure that that is now part of someone's responsibility and that we're going to take a proactive approach to the outreach.
Yes, so we are in the process of recruiting a communications and legislative affairs manager. And the function of the legislative affairs aspect of that position will be to monitor proposed legislation that comes up. In addition, the management analyst that we'll be hiring in the city manager's office will help support that as well.
Yeah, like I just can reflect on last week. I was at the legislative breakfast with Senators Ben Allen, Holly Mitchell, Assemblymember Mike Gibson, Senator Stephen Bradford, Congresswoman Maxine Waters, and Janice Hahn. And it would have been really good to have someone in this role there, to at least be there absorbing, disseminating information back to us, organizing our thoughts. And I think, to your point, Carol, we need to do more to advocate. I mean, we're doing it at a local level already with LAX and some of other constituents, but I think we need to do more so at the state level. And we have many ways to do that. Every one of us is on like you're on the sanitation district sometimes, Chris, and other committees, Scott, Carol, I'm on COG. I think there are many opportunities for us. And when we have alignment on these issues, it's very easy for us to voice a similar song, essentially. So I agree with Chris, though, that we should spend some time. I don't know that we need to put it back on the agenda, how we address this. I brought it to you up earlier, but how we get everyone on the same page. The vast majority of these strike me as kind of no-brainers, but then there are a couple that stick in the craw a little bit.
Mr. Mayor, members of the council, let me throw out some reassurance and then a suggestion. So having this platform gives us flexibility when we need to use it. And staff would not be sending off letters or making calls unilaterally on our own. I envision that there'd be probably a handful of times throughout the year, actually, letters would be done in this fashion, and they would go out on the mayor's signature. And if the mayor's not available, then the mayor pro tem. It would be very rare for it to come out on staff's letterhead. I'll give you an example. I think it was 2 weeks ago, one of the council members had contacted me about SB 50 because it was coming to a vote, and wanted to know if the city was going to take a position. Well, we hadn't gone to council. We didn't have the authority to get the mayor to sign or to make a call on your behalf. So that was a rare incident where I did, as city manager, call our state senator's office in Sacramento and our state assembly member's office to convey general concerns that the city would have. But had we had the platform, we could have just got that letter and done that, or had one of you call on behalf of the council that were on the platform. So, and also, we will be very judicious with respect to taking a position or advocating taking a position. And if I don't sense that we have the majority of the council on it, or if it's not clear, we're not doing it. So just to give you that assurance. Having the tools in the toolbox are good doesn't necessarily mean we're going to use them. And so I would encourage you to go ahead and adopt it, and then we'll make changes. And if you go through this and you say, hey, well, I'd like to take these out, we can take them out. But that would be the suggestion. Thank you.
And then just for clarification, there is the monthly Governor's Affairs meeting that happens by the chamber, and a lot of these bills are being pushed, presented by each of the representatives. So it would be wise then if this new person attended those and made sure that they were up on speed, because a lot of times I hear about these new bills at these meetings, then I come bring it back and question. Or I read about them in the paper, and I have brought many to the city, like what's going on with, what is our status on this?
Yeah.
So I just think as long as the list isn't just a list, and there's a proactive process to the list, then I'm happy with it. But it's just, I shouldn't, I know sometimes I'll find out something and I'll bring it to the city, and the city's not aware of it.
Right.
It's more frustrating. But if the city's already aware of it and they're proactively letting us know, hey, this is coming up, you should be aware of it, that would be where I think I would like to see the city going, in that direction.
Yeah, I think, sorry, I just was going to add, that is the direction we're going. We certainly don't want to just put this in a, 3-ring binder and put it on the shelf. It's a living document that we're going to be looking at continually. And as things come up, as we monitor legislation, and I think that's a great suggestion to go to the Chamber's Government Affairs meetings, reviewing other California League of Cities and other sources of information regarding pending legislation, we'll make adjustments to this as needed.
Right, and it's important at the government affairs meeting, we get a lot of feedback from our local businesses on their status on their perspective of these initiatives. So it's a really good arena to learn what our residents and our business business owners feel about certain bills coming down the pike. So.
Absolutely.
Okay, not to be a broken record, but how are we going to measure success with this position? At the end of the day, we look at what are the specific outcomes this woman or man will help us achieve. And if you don't have the answer, it's okay, Barbara, but I'd love to hear you come as we go post. I'm hoping in the job description or as we have conversation
Well, I
through
have
the
an
interviews.
answer in my head.
Okay.
Hasn't been written down anywhere.
Okay.
But I think it's an ongoing measure of success that as new legislation is proposed each session, this person will be responsible for digesting that and able to translate it into something that's simple and easily understood. So that will be one measure, is that process of almost simplifying, understanding, and communicating what's on the horizon. And then another measure is our advocacy. How many letters are we writing? Were things that we advocated for approved or not approved, passed or not passed? So those are some of the ideas that I have.
That's good. Do you think this person would actually help shape legislation? Because one thing we heard loud and clear last week from all the legislators at the state level and Maxine was, listen, SB 50, do not be thankful that that's dead.
Yes.
Because that is just going to show up again in another form, in another bill, potentially another author. Housing is coming, and the more you can work with us to help shape how that will work in your towns as opposed to us just forcing down those mandates, the better. So I think they're open to dialogue. I mean, it didn't get the votes in the Senate, and Ben was one of those that I think was opposed. So do we think this person would actually digest and then come up with recommendations for council from a policy standpoint to help shape as well?
I do.
Okay.
I do. I think city manager, my role, and this person, as long as we all have a clear understanding and then we're able to communicate to our local legislators what that position is, I think that will go a long way. And I just had the conversation with Senator Allen at that same meeting that you mentioned, and he was looking for that kind of input.
I forgot you were there. Sorry, Barbara.
No, that's okay.
You're sitting right next to me.
Yeah. I'm forgettable. What can I say?
No, not at all.
Mr. Mayor, members of the council, you're going to be pleased with not just the person, but the approach and the program we're going to deploy. Some of the more far-reaching legislation that's been beneficial to cities came out of individual cities through this type of program and function. There's also the legislative conferences and sessions that are held in Sacramento. We would have this person go up there to represent us and to attend and then come back and report and share with the council. So it's given the complexity of our local economy in this community, we need to be more involved at the front end. And it's not just legislation, it's also regulations. If regulations are having a negative impact on our businesses or our city services, or we need more regulation, this person will be tracking that. And we'll use this forum to do that. I should also add, several of your departments are really up to speed in monitoring on their own, and they have their own associations that track this. So our legislative affairs person will be coordinating all of that. And we'll have a regular report for council so you can see what's going on and better understand it. You will be pleased. So thank you for your consideration.
So Scott, while you have the mic there, just for our viewing public at home, we're talking about a human, a person, but fiscal impact, none. Correct?
When you say none?
I'm reading this. It says fiscal impact.
fiscal.
Oh.
Fiscal impact, none.
Yeah, of receiving the report and setting up this process. But as we have a more robust program, yeah, there will be potential of a significant impact to the good of the community. But that's once the program's up and running.
I think he's referring to the position itself.
I'm referring to the position and the head count. You know, we've sat here and said, you know, we're not hiring new people, we're not adding head count.
Yeah.
And so if you're at home and you happen to be looking at the agenda, you're like, why are they talking about a person when there's no fiscal impact? So what's like, so that the public knows.
Yeah, well, the position coming in, that's already in the budget and it's already budgeted for.
It's not a net new position.
Yeah, it's not net new. And the legislative platform itself, for you to adopt it, there's not an impact of this action. But your point's well taken. Once the program's up and running, we feel it's going to have a positive impact. So I hope I'm answering that question. And if I missed it, I'm sorry.
You're okay.
Okay.
The position came from some other place within the organization.
Absolutely, yes.
Yeah, and that was part of the proposed budget process and all of that. Yeah.
That's, I think, what Scott was looking for more specifically.
Okay,
Thanks,
I
Joe.
apologize.
Okay, so then I know that you had some items you wanted to pull from it, and you did. Did you
Oh,
wanna come
I don't
back?
have any that I want to pull tonight. I'll defer to Chris. But
Yeah, no, I think what the general recommendation from the city manager is we can adopt it now, and as we move forward and discuss it, because it's a living document, if he senses there's things out there that are not going to be a part of it or require further deliberation from it, he could just yank them off.
I mean, it states clearly in the second paragraph here, you know, that it's clear direction to the city manager to respond and take actions quickly under the direction of city council. So if we don't agree with something,
It's not happening.
then it's not going forward.
Right, and you will be made aware before something goes out. And it would go out on the mayor's signature.
You know, I think that's the most important thing for me, just because it's, you know, Drew, Carol, Chris, and Scott right now, but it's not always going to be us. And so we don't want to set policy that the others would have to inherit.
Yeah, and it will change probably over time. Okay, do we have a motion to approve?
So moved.
I'll second. All in favor?
Aye.
Great job, Barbara.
Thank you.
Thank you. And Scott and everybody else and all the department heads. Thank you. Okay, number 7, receive and file 2018-2019 year-end financial review of general fund and enterprise funds. Joe, up here for a second time. Ready to go?
And then we've
Tee
got
up the presentation here.
Oh, yeah.
5 and 7, right?
Joe, are you reporting both on both 5 and 7, or is someone else going to present 5, which is the work plan, year-end report? Scott,
So this is the work plan.
Okay, great.
First item, and then the second item that I'll be presenting on is the fiscal year end.
Great. Okay, thanks.
All right. So good evening, Mayor, City Council members. So this is the work plan status as of fiscal year end 2018-19. So that brings us through September 30th, 2019. And this would have been the work plan that we met with council during strategic planning in the summer of 2018. So the one we just did this past summer, I'll start bringing quarterly updates again to you moving forward. All right, so there are a total of 59 activities that were identified in the strategic work plan for 18-19. There were 11 Tier 1 priorities, 17 Tier 2 priorities, and 31 other activities, and I'll describe what that means real quick. Tier 1 activities are defined as council's top priorities. So that's that voting that council did, and those are the ones that received the top votes. So there's 11 of those. Tier 2 activities were defined as these will be projects that pursued as resources permit. and the other activities are defined as future opportunities. Out of the 11 Tier 1 activities, 10 were completed in 1819, during 1819, or began our long-term ongoing processes. One tier activity was delayed until 1819 and is currently underway, so that will be completed in 1920. Of the 17 Tier 2 activities, 14 were completed during 1819, and 3 are expected to be completed during the current fiscal year. There is an attachment A in your staff report that outlines each of these activities. I'm not going to go through all 59 individually. If council does have specific questions on any of those at the end of the presentation, I'm happy to answer. As for the 31 other activities, 27 were completed during last fiscal year, and 4 are expected to be completed during the current fiscal year. So none of the 59 identified activities are expected to be unattainable. That's great. 87% of the work plan items were successfully addressed during 1819. I think that's a great testament to staff's dedication and getting these work plan items that council identified as priorities, either top tier priorities or other priorities done. And we are currently underway in 1920 on the work plan items that council identified as top tier priorities during the strategic planning session in the summer of 2019. So it does conclude my presentation. Open to any questions.
So that basically confirms that the strategic planning works.
Absolutely. I think it's very successful.
I got a question on the priority one item that hasn't been completed, which is the new approach to HR that will position the city for being a choice employer and meeting future workforce needs. Does that include the HR audit that we asked for a couple years back that was conducted, that we weren't entirely happy with the results, or at least the way in which the study was done? Is that included in that priority, or is that exclusive?
So that HR audit, no, it's not, and that was done. So the HR audit was completed during 1819.
I think, if I recall, it was we were looking for a comprehensive audit on process.
Yeah, I think what I recall is that there were some concerns about the level of rigor or resources available at that time when the study was conducted, and we weren't entirely happy with the results. So I'm just wondering if we're still, what are we doing with that? Because I don't recall seeing the results, because I don't think you guys were happy with them, right?
So, I don't know if Mr. Serrano, HR Director, or Mr. Mitnick, the CM, would probably be able to answer that a lot better. So I got that audit kicked off and then handed it off to Mr.
Right.
Serrano. So I have not been involved in that for quite some time.
Right.
Yeah, I'm not sure if we saw any.
I don't think so.
Mayor, members of the City Council, so the audit was completed. When we looked at the results of the audit, there were some 220 recommendations. Of those, most of those were sort of benchmark best practices. We did identify about 48 that I call legal compliance pieces regarding human resources management. And so we're trying to fix those 48 as our primary objective. To make sure all of our processes are legally compliant with current standards and current regulations in terms of employee management. The remainder are all benchmark process things that we'll get through that are going to require some meet and confer obligations and some other things throughout the process.
Okay, so you're working through the results, and at some point in the future, we'll get an assessment of how we're doing?
Yes.
Okay.
And then part of that process, do you have you created a time frame for update audits to ensure that all these things are getting closed, and like what is your timeline to accomplish all these?
So of the 48 items, we sort of have a checklist, and we're sort of checking off the boxes, and then we go back through to ensure that the process is fail-safe going forward as a regular benchmark item.
Okay. I just think we should, maybe in the next couple meetings, we should get just an overview what that is, because I know we did not see a presentation from that audit.
Sure.
Mark, any thoughts on that?
Yes, the audit probably could be applicable to virtually any, as I reviewed it, and I did not, it was quite lengthy, I reviewed in summary, and I reviewed some of the detail too, but in large part, it could have been applicable to any public agency. It wasn't necessarily tailored. And so a number of the items, and one of the issues at that time, staffing was down, and so the person doing it wasn't able to determine whether all of the required legal issues were in place. I mean, as far as documentation and whatnot. So that, to me, was problematic, and I know that David and the city manager are working on it, but while the number sounds high, the actual number of issues is much lower than the numbers that were just put out. And also, I would note that every year, there's legislation and federal laws that require probably another 10 or 15 issues that have to be addressed from an HR perspective, which that's probably the most important thing. Is as far as what is required from past laws, the city is generally always in compliance with those. It's the ongoing changes, and there are lots of them every year that need to be stayed on top of. And
Well, one of the things I know that we had talked about is looking at an HR system and an upgraded HR system, because we're not on it's quite antiquated. And I know that after reviewing the IT initiatives, it wasn't on there. So I think we just need to, if this is a priority, and if you have an updated system, all those new regulations should be, updated automatically for you. So if maybe the focus should be on getting a new system to help us, and I mean, I don't know the extreme details, but that's something I think maybe we should be talking to Charles Batten in the IT committee.
yeah, I can see already, and it's coming out in my field, and this will be applicable to HR. I think it's not quite there, but the artificial intelligence and tracking of issues and those type of things, I would think over the course of the next couple of years that having more automated processes. As far as the changing laws, now we have, in El Segundo, we have some personnel laws, if you will, that were adopted by the voters some 70, 80 years ago, and they're a bit antiquated, which is its own problem, and we've talked about that.
We just talked about that today, about maybe bringing some of those bringing those forward, and let's get them changed, and so that we can be up to date.
And one of the challenges, and I know we've talked about this with those, is some of those require meet and confer with the various unions, and so not that it can't be done, but it is time intensive for some of those issues. But those type of things are unique to El Segundo. There are other cities that have personnel laws that were adopted by the voters, not a lot, but some, and so it's difficult as things change with voter enacted laws and adapting to that. But we're working on that. But again, I think that in large part the audit was a little over-inclusive of issues and might have been more helpful if it was more focused towards the city of El Segundo.
Thank you.
And just to address your concern, Mayor Pro Tem, staff, HR staff, finance staff has been going to a lot of training. So any new state, federal regulations that impact HR, finance, payroll, employees. We've been going to, like LCW has a consortium that we belong to, a lot of web training, a lot of in-class training, annual finance conferences. So staff has been getting trained on that, where I think in past years, staff was not involved in that training.
Oh, that's good.
Any other questions on this item?
Sorry, just one, I think, which is for years we've heard our predecessors talk about the Prop 13, the way the property tax allocation was done, and so little of which we get from the residential property tax vis-a-vis our peers. So I see that on here still, and I know it looks to be something that we hope to get done. What's that, 2019, 2020? Yeah, that's now. How's that? It says in preliminary discussions with other cities. We haven't really heard an update on that. Any news to share on that front?
So it definitely is a hot topic. So I belong to the policy committee with the League of California Cities. And the policy committee that I'm on, that is definitely a topic that was brought up 2 weeks ago when I was there. It has been brought up at the CSMFO conference that I was at last week, which is California Society of Municipal Finance Officers. So that discussion is happening within the profession and within I think some of the platforms that exist out there, like the League. Yeah, I think that's a good starting point. And there are several cities in the South Bay and throughout California that are low property tax cities.
Maybe this is something the new analyst could work on that Barbara was referring to.
Yeah, I think the biggest challenge is, we talk about on here, I think the goal says possibly work on a state ballot. One of the challenges there is the large cities who have a larger portion, they would have to give some of it up. I don't see voters willingly giving up a share of their revenue.
Thanks, Joe.
This might be something for a future legislative analyst, but there are, I think, 2 different gestating ballot initiatives, aren't there, on Prop 13 that would split the commercial property from residential, which would certainly bear an impact on our outlook to it. So,
Okay, one last, sorry.
Yes, sir.
There's one on software. Use the full potential of software, that's a bear right there. And it's a yellow one. So we're defining that as success with the Eden requisition model, which is your department, Joe. Conference call capability, document imaging, which is almost done, and the Eden HR module. So to Carol's question earlier about the HRIS, are we thinking that the Eden HR module could be our HRIS, like Human Resource System of Record and IT,
With the Eden system that we have that was installed in the early 2000s, no. We will have to look at a more robust platform, and I think looking at our whole entire ERP system and looking at a new ERP system, which I believe is in the works. Charles and I are already talking about that, maybe bringing that as a discussion point with the tech committee sometime in the near future.
Yeah.
I think we'll roll up in that larger discussion.
We have 2 big projects. One is the whole ERP system, and then one is the planning and planning department system.
Is that something we'll be considering through strategic planning for next fiscal year?
Yeah.
Or?
Well, I know we put money in the planning system for this fiscal year. What was delayed, we just didn't have the resources, but I believe that is now starting to, now with the launch of the website, I believe that's the focus. Right, Sam? So I think hopefully maybe a year from now is the implementation date? 18 months, yeah. So I think the HR system should be definitely second up, teed up in getting ready for that.
Now, with our existing platform, the Eden platform, we have gotten a full potential use out of a lot of the different program options. Purchasing now, we're paperless, 100% paperless there, which is great. The payroll, paychecks now are 100% paperless. So we have definitely, initiated some of this in 18-19, but there still is a long ways to go.
Okay. Yep. And one of the huge successes is the launch of the website.
Absolutely, yes.
That we just launched this last week. And then we're also implementing a time and attendance system.
Yes.
For part-time employees. So there's been a lot of, talked to Charles about getting the tech committee to give us an update, because they've had a lot of successes in the last year, and with the staff as well. So it would be kind of time for them to give us a presentation.
Absolutely. Okay. Any further questions? Okay.
A lot of good work happening. Thank you. Great progress.
That was the finance director's warm-up act. Now he's shifting gears. Returning to the podium.
All right, I was advised by Fire Chief Donovan to make this brief, so. All right, good evening, Mayor, council members. This next item is a fiscal year end financial review of the general fund and the enterprise fund. So that would be water, wastewater, and golf. I'm going to touch on the general fund first. So we had originally budgeted revenues of about $74.5 million. We're coming in, again, these are unaudited, so the audit is still ongoing. We anticipate the audit should be completed sometime early March. So year-end revenues unaudited are $78.8 million. So this is about $4.3, $4.4 million above what we had anticipated in the budget. And I'll get into those key differences in a couple slides from now. Budgeted expenditures were about $79.1 million. The year-end expenditures unaudited came in at about $77.9 million, so that's about $1.2 million less. So obviously, higher revenues, lower expenditures results in a net positive gain to the general fund balance. So the anticipated general fund balance was about 14.9, and we're looking at it's probably going to be about 17.6. All right, so to touch on some of the key revenues, again, there was about $4.3 million that revenues came in higher than what was budgeted, and some of the top variations, sales and use tax, $1.1 million. $1 million of that is a result of one-time funds that what's the new acronym? CDTFA, that's prior they were called the Board of Equalization, so they did change their name, CDTFA. When they switched from BOE to CDTFA, they also switched the ERP system that they're using to collect and report sales tax throughout the state. They found a glitch, and every single city across the state they owed money to. For us, it was the equivalent of $1 million. So we did get a payment in late 2019 of $1 million. Again, that was just a one-time payment, so that's the bulk of that $1 million. UUT, utility user tax, $950,000 above what was anticipated in the budget. About $536,000 of that was in the electric UUT, so higher electric UUT than anticipated in the budget, and $273,000 from gas UUT. License and permits, a total of $653,000 above budget. That's due to the strong economy. Allowed for increase in development activity, including several tenant improvement projects that allowed for higher revenues on building permits in general. And we're going to see that also had a positive impact in the water and wastewater funds, which I'll get to in later slides. Cogen Electric, higher than anticipated production in power plant operations allowed for almost 60% additional revenue than originally forecasted. Business license, total of $425,000 above what was anticipated in the budget. About $100,000 of that is from higher filming permit revenues, and $325,000 from business license. That's really, the local economy continues to be strong, and economic development efforts continue to attract new businesses here in the city. Property tax, pretty significant increase as well, $411,000. This is really due to an increase in property values and a change in ownership of property. So we had some commercial properties that changed ownership, so that gets reassessed, and then obviously we benefit from that reassessment. Same with residential. There was quite a bit of residential sales. Some families have owned those homes for generations and now sold to a new owner, and those homes are reassessed as well. So any questions on the revenue side at all?
Do we think that, I mean, historically, our UUT and cogen budgeting has been either higher or lower every year, depending? We've been having trouble trying to figure out what the main drivers of those are. Do we think that they are elastic to the economy? We're just seeing higher production in new facilities, or do we think those are just outlier numbers? Because we've over budgeted it previously and seen large underages, and thinking that that reflects the new way that the electrical grid is structured with renewable energy. Do we think these things are forecastable?
So we do have a consultant we use, Muni Services, for our UUT forecasting, and they provide us a 5-year forecast history for UUT. And they provide 3 scenarios: a conservative scenario, kind of middle of the road scenario, and an aggressive scenario. And we typically use the one that's down middle of the road. And then they send us a new forecast each year. So it's a rolling 5-year forecast.
And it's still wildly inaccurate each time. I mean,
it is.
But
So
we don't know what drives it. Or we don't know what is the outlier that is pulling it one way or the other.
So natural gas commodity prices, that's one of the main drivers there, and that has fluctuated a lot. It depends if business changes their operational use. There's just a lot of factors there. So it is one of the more difficult revenue sources to forecast and to budget for.
I think we were under by 600,000 last year.
Correct.
Right? Off our
Yes.
budget. Yep.
Yeah. So we went a little bit more conservative this year, thinking that trend was going to continue, and then we ended up higher.
Okay.
Joe, sorry. Sales and use tax. We've been talking about how sales tax is on the decline and demise of brick and mortar retail. How did that 13 million compare to last year? I'm just curious. I know what our budget was, but
we were right around the high 11 million, so maybe 11.8, somewhere
so it
around
grew.
there.
And how do you explain that? What do you think contributed to that? The growth in sales tax, as we've seen more retailers. I mean, if you just look at the point.
So
I'm sorry, Plaza El Segundo, we've seen some retailers shut down.
Yeah, our total sales tax has stayed flat. The delta between this 11.9 and the 13 is that one-time correction from the CDTFA when they changed their system.
Yeah, I'm just surprised and flat even. We haven't changed our sales tax rate, and we've seen some retailers continue to struggle.
Right.
It'd be interesting to see what you budget for next year.
So for the current year, I believe we're right around that 11 point.
Same. Okay.
Right.
All right. Thanks.
Okay. Any other questions on revenue? Okay. Okay. So general fund expenditures. Again, the total budget was 79.1 million. We came in at about 77.9, so 1.2 million under. Some of the main drivers there were, on average, we had about 25 vacancies throughout the year. So that contributed to the savings. It would have been more, if you recall, going back to November of 2018, City Council approved both the POA and the FFA MOUs. And there was some significant increases, budgetary increases from those MOUs. We didn't do any budgetary adjustments. I had told City Council at the time that because of all of our vacancies, that would be enough to absorb the increases due to the MOUs, and it was. So we didn't make any adjustments due to those new MOUs. And we ended up with savings of about 1.2 million, and again, that's due to vacancies. So police and fire came in higher than budget, and again, that has to do with the new MOUs. And again, we didn't make any budget adjustments. We knew that if you look at the general fund as a whole, there was enough to cover those MOU increases. This line here, the admin support, which is city manager, city attorney, city clerk, HR, came in right around what we anticipated the budget to be. Public works came in under. Again, that's due to vacancies, and another big discrepancy was recreation and parks. Again, there's several vacancies there throughout the year as well. Any questions on the expenditures, general fund?
Where does litigation sit? Is that city attorney?
Yes, so I just lumped all the, what I'll call admin support together. It was right on budget. All the departments were pretty much right on budget.
Although the, depends on what you put in litigation, like workers' comp and
general liability.
General liability is in non-departmental.
No, they're in different funds. So it's Fund 602, 603, the workers' comp fund, and the general liability fund.
But aren't those all lumped into non-departmental? Or did we change the title on those? Okay.
No.
I'm sorry, I was trying to be, so are those all in number 3?
No, the litigation costs due to workers' comp
Right.
cases.
Yeah,
Or
those-
general liability are not in the general fund. Those are in the internal service funds, which is Fund 62603. So those, we put those costs in the internal service funds.
I just wanted to be clear that those weren't included in that number.
Because that's a big number.
Right, those are big numbers.
Yeah, that's 3% of our budget.
And it's not necessarily like in workers' comp, it's not the litigation costs that are big, but it's the workers' comp payouts that are big.
Yeah.
Right. Okay, any further questions on the expenditures? Okay. And speaking of general liability workers' comp, I did have our third-party administrator, TPA, Adminster, come in and give us an annual review of our general liability program. City Manager, Mr. Mitnick, was there as well. We are the best performer in our pool for the general liability program. So it's a good win for us there. Workers' comp is a little different story.
That's a massive turnaround.
Yes, yes, for the general liability, absolutely. Okay, I'm going to skip this slide. I'm going to focus on this one. So this slide focuses on, this column on the left is what we anticipated we would end up with the adoption of the current year budget. So we anticipated we would have about $53,000 left over by the end of this fiscal year, so looking at September 30, 2020. So again, this is with the adopted budget of 1920. Now, with the numbers I just told you, the higher revenues, lower expenditures, our fund balance ends up higher in the beginning of the fiscal year, and we end up with about $2.7 million in undesignated reserves, which we'll have a discussion during mid-year with City Council on how to allocate that, utilizing our strategic plan and Council's top priorities. So there are several priorities there that are not funded, and we'll bring recommendations to Council on how to fund those priorities with this $2.7 million. Any questions on that at all? Okay, as for the enterprise funds, this first one I want to touch on is the water fund. So we had budgeted revenues of $30.7 million, and then on the report that I did, that myself and my staff put together, $37.2 million. So obviously that's a big variance, $6.5 million. I'm going to go over that right now. $2 million of this was attributable to increased recycled water sales to Chevron. So we noticed the trend for Chevron. They did increase their purchase of recycled water during the past fiscal year. Typically, they purchase about 16 million on an annual basis of recycled water. So that went up by $2 million last year.
Do we know why? Did production go up? Does that have anything to do with what they buy from West Basin?
We're
or
going
is
to
it
be
different
reaching
use?
out to them
Okay.
and to figure that out, and if that's going to be a trend that's going to continue.
I mean, that's really, I mean, it's a very positive because I know it costs them more to buy that recycled water than it does regular water, correct?
No.
It doesn't?
No, we don't charge them more.
Okay.
$1 million was associated with new connection fees and deposits. So that's new businesses coming into town, which I talked about earlier. Our economic activity is booming here. $750,000 was due to increased interest income earned on the fund balance sitting in the water fund. So our rates on our return on our portfolio, internal portfolio, increased. Also, the fund balance increased, so $750,000 above what we anticipated in interest income. And then $2.8 million is an accounting accrual correction that we need to do. So this number is actually going to go down. This $37.2 million is going to go down by $2.8 million. And that will be shifted into the current fiscal year 1920. So the enterprise funds, we use full accrual accounting. So that adjustment needs to be done. That's why, we are saying, unaudited. So, as far as the expenditures, we came in about $2.2 million under budget, and that was just CIP that had not been fully completed. That's carrying over to the current year. So about 2.2 million in carryover CIP for water infrastructure replacement, basically water mains. Wastewater fund revenues here were about 1.3 million over what we anticipated in the budget. $410,000 associated with new connection fees and deposits. $375,000 was from a developer fee check to the wastewater fund. $165,000 due to increased interest income earned on the fund balance. And again, $315,000 that is going to be an accrual, so that number will decrease by $315,000 on the final numbers for the CAFR. Expenditures coming in about $862,000 under budget, and again, that's this carryover CIP that's ongoing. The golf fund, their revenues came in about $190,000 over anticipated budget. So we took, during the development of the budget in 1819, the whole Top Golf thing was a little bit uncertain. So we did, I think, take a little bit more of a conservative approach with the budget development for 1819. So there were a little bit higher revenues than we budgeted in the golf course and driving range. Expenditures came in about just a little over 220 under budget, and that was lower expenses in the golf course operations, food and beverage operations, and the driving range. Any questions on golf operations?
So what is their net?
Well, the golf course as a whole has a deficit fund balance position, about 5.7 million. So this will just lower that, I'm not doing the math in my head right now, but by a couple $100,000. So we do still have that outstanding loan that I will be addressing with council in the
That deficit includes that loan balance, correct?
The 5.7 million, yes, right. Correct. Any further questions on the golf operations? Yeah, I do want to point out, the expenditures, that does not include, we didn't invest anything in infrastructure. And that's, my staff took a tour there with Meredith Pettit, and I believe it was Billy Casper, I think that's who it was. And there's things that are really run down, in bad shape, bad condition.
Joe, back to the water fund really quickly, the projects that still need to be done with the lifeguard pump or the drain line and all that stuff. How are we paying for that $7 million? Do we have another, I can't remember if we have another fund, capital improvement fund for water?
So 5 years ago, when the 218 process was done for the water, wastewater funds, it looks at both the purchase of water, because we buy 100% of our water from West Basin, which gets their water from the State Water Project. So it looks at those costs and what those increasing costs are. We also look at the infrastructure that the city has to maintain. And so that's built in the total rates. So both the operational and the CIP needs are built into the rates. So there is a built-up reserve of CIP within the water and wastewater funds, which those are the 5-year the 5-year 218 process. It's already come to an end. We're going to start that again here real soon. I believe the next council meeting we're going to start that discussion with the consultant. So those reserves for the CIP are getting very low. So we're going to talk about what that means for going forward.
Sorry, I misspoke. The wastewater one. That's the one that I think is going to help us address the lifeguard station, getting that plumbing line tied in to Chevron's line or whatever. How are we, that $7 million, are there similar funds in the wastewater capital improvement fund, or what are the reserves like for that one?
Where's the $7 million you're referring to?
It says the last paragraph of the last sentence of the first paragraph under wastewater says a total of $7.6 million for the lifeguard force main and pump station, annual sewer main repair, sewer pump station number 1, rehab of pump stations, and AMR meters.
So that's I'm assuming that's going to be what our CIP reserve, total reserve is for those items.
But is that our general CIP fund, or is that, are there
It's within
funds
it's within the
wastewater?
water and wastewater funds, yes.
How much is there in there? That's what I'm looking for. Do you know roughly?
I want to say the water fund, I know was close to about 10 million. The wastewater fund, I didn't think it was that high, but I can get the numbers and present that next council meeting.
Okay.
Yeah, and also, can you double check on that? I do believe Chevron pays a premium for recycled water. So if they're buying more recycled water over regular water, I just want to understand that.
I think there's a premium they pay, but I think it's tied to our rate that we charge for potable water. So other consumers of recycled water in the city are billed a lower rate than Chevron is. Okay, one quick slide on pension strategies. Total cost savings to date, $11.7 million. And the reason why I put this on here, I wanted to touch on this. So council did approve the pension trust, I believe about a year and a half ago now. We do have a pension trust balance of $4.37 million as of December 31st. And really what I wanted to point out here is the annualized rate of return as of December 31st, 17.62%. And we're getting about 2% on our internal portfolio. So this is a great place. We're beating CalPERS as well. Their discount target rate is 7%. They're anticipating they're going to land at about 10% their fiscal year, which is June 30, 2020.
Is this thanks to Dino and Krista?
I'm sorry?
Is this as a result of Dino and Krista?
Absolutely. They're a big contributor to this, yes. All right, so concluding, at the department level, city spent under budget mainly due to the vacancies. Once the 18-19 financial audit is complete, we'll bring the CAFR presentation to council. That's probably going to be the second meeting in April. And then mid-year, which will be in May, hopefully the first meeting in May, we'll discuss how to allocate that $2.7 million towards council priorities. All right, that concludes my presentation. Any further questions?
I do. When we do the mid-year, could you bring to us the trend of the number of vacancies we've had over the last, say, 10 years? Because I'm just not sure, we've been, vacancies have allowed us to keep our expenses down, but maybe we just are keeping too many headcount on our roster. And I know you had added something to the budget as a, I'm not sure what you called it, something to offset that.
Yes, so this current budget, we used the 5% vacancy rate, so that's built into the budget.
Right,
which
so
was
I
a
just-
little over $2 million.
Because if we consistently have 30 vacancies every year, well, then maybe we should relook at the number of vacancies we're holding on our roster, on our budget. I just want to see that trend.
Any further questions?
No.
All right,
Well
thank you,
done,
council.
Joe. Thanks for protecting our financial interests again. Okay, I think that's it for staff presentations. Going to move on to reports. City Clerk.
We currently have that, excuse my voice, a vote by mail drop-off box in our office. So if anybody works in the city, they can drop them off. And also vote centers. The city will have 7 of them. So we were worried we would have only like 1 or 2, but we have 7.
Is that already on LAvote.net? Or were they? Great.
And what's the last day to register to vote to be in this election?
The day of, you can now vote, you can now register to vote the day of March 3rd.
Wow.
Oh, wow. So that's a change.
Yeah.
That's good.
And of those 7, 1 of them will be open for that 10 days prior, and then the 11th day, and the other 6 will be for the 5 days.
Well, do we know where the one is?
Yeah,
That's
I knew
gonna-
you guys were gonna ask me, but I forgot. But
That's okay.
They're all over.
LAvote.net.
There's like Center
Okay.
Street, Richmond, Center Street, the Moose Lodge. I'm just thinking off the top of my head, library. They're all over.
And what's the last date to register to get to be vote by mail?
I don't have that with me, but it's coming up.
It's coming, okay.
I can look.
Just-
Actually, when you get your sample ballots on the back, you can request a vote by mail ballot there. You can also request to be permanent if you like. Questions?
Thank you, Madam Clerk. All right, City Treasurer, I don't see any representatives. Councilmember Pimentel.
Nothing to add.
Thank you, sir. Councilmember Nickel.
Councilmember Pimentel, myself, and Mayor Pro Temp Persta, along with Barbara Voss and Greg McLean, sat through a roundtable with Congressman Ted Lieu regarding the census and how important it is that this count, this 10-year count, and it's estimated that for every person counted, the city will receive up to $2,000 per year, every year for the 10 years. And so when you get your census mailer in the mail, please fill it out. Please do the count the best that you can, because those dollars go straight towards infrastructure and parks and everything that we try to do here as a city. And the other thing that they spoke about in California, and why California is considered a hard-to-count state, because there's just a lot of urban areas, a lot of density, is that it's something like if the state fails to count up somewhere around 40,000 individuals, which doesn't seem like a lot when you're talking about 40 million people, we could lose a seat, we could lose a congressional seat, and we can lose an electoral college number. So the count is important. We encourage everyone to fill out their forms, and you'll be getting 3 mailers starting on March 12th.
12, yes.
Yeah, that'll be the first mailer. So look out for it in the mail and fill it out. That's all I got.
Thank you, sir. I recently read that we will likely lose a couple electoral votes regardless because of the decrease in population to Texas and Idaho. Mayor Pro Tem.
Yeah, and I just to finish up, to add to what Councilmember Nickel was saying, the date that you're supposed to take the snapshot is April 1st. So when you do your count, it's everybody in that, on that property, not just necessarily your household, but you're on that property for that address on April 1st. So you have to be you have to anticipate who's going to be in that. So if you have kids in college and they're not in their in the house on that date, you're not supposed to count them. They'll be counted at their school site. So just real to Councilmember Nichols' point, we really need to ensure El Segundo is counting everybody. And we do have a bit of a competition going on with our local South Bay cities, and we would like to win. Thank you. That's all I have.
Thank you. I had the privilege of doing a ride-along with Officer Marco Lemus last week and Linda Watson, who's a mental health professional, through the homeless plan that your department put together, Chief, and we got funded through the Council of Governments. And I just got to say, congratulations, great program. I had the opportunity to speak to 3 homeless people on that day. The officer and Nicole knew exact. Did I say Linda earlier? I meant Nicole Watson. They knew exactly where these people were by name. I still remember their names. I remember their stories. And it just struck me how vulnerable many of these people are, how they're skeptical, dubious of help being offered, maybe reflecting on past experiences. One individual was like, I'm not going back to Skid Row. I'm not going there. I've been there. Nothing you can tell. And how much perseverance and humility and grace and compassion it requires on a regular basis to establish those touch points and eventually hopefully develop trust and offer assistance. So I learned a ton. I really appreciate the opportunity. And then I just final thing is there is the COG is doing a Sacramento lobbying visit similar to what we talked about earlier, March 24th and 25th. I'll likely be attending, and if anyone would like to join me, that's great, and or share your thoughts. So I just want to put that out there. That's all I have for this evening. City Attorney.
Nothing this evening. Thank you, Mayor.
City Manager.
Mr. Mayor, members of the council, the next council meeting will be on February 18th, and the agenda is shaping up. Thank you.
Thank you, Mr. Mitnick. All right. Public communications. Now is the time and place. Seeing none. We are not going into closed session. We're going to close with a memorial. We're going to adjourn in the memory of Kobe Bryant and the 8 passengers that perished on January 26, 2020. If you allow me a moment, I'd just like to read something, and then we'll take a moment of silence. Kobe Bean Bryant, lifelong LA Laker, born August 23, 1978, tragically passed away January 26, 2020, in a helicopter crash at the age of 41. Kobe, a shooting guard, entered the National Basketball Association directly from high school and played his entire 20-season professional career with the Los Angeles Lakers. Kobe led the team to 5 NBA championships, was an 18-time All-Star, 15-time member of the All-NBA team, 12-time member of the All-Defensive team, was named the 2008 NBA MVP, and was a two-time NBA Finals MVP winner. Widely regarded as one of the greatest players of all time, he led the NBA in scoring during 2 seasons, ranks 4th in the league's all-time regular season scoring, and ranks 4th in the all-time postseason scoring list. In 2006, Kobe scored a career-high 81 points, the second most points scored in a single game in league history. At age 34, Kobe Bryant became the youngest player in league history to reach 30,000 career points. He became the all-time leading scorer in Lakers franchise history on February 1st, 2010. Kobe was also the first guard in NBA history to play at least 20 seasons. Kobe's stats are never ending. Kobe Bryant was not only an NBA champion, he was a caring father, husband, coach, champion of youth sports, and philanthropist. 8 others, including his 13-year-old daughter Gianna Gigi Bryant, 13-year-old Alyssa Altobelli, mother and father John and Carrie Altobelli, 13-year-old Peyton Chester, and mother Sarah Chester, coach Christina Mauser, and pilot Ara Zobayan were also killed in the crash. Kobe and Gianna are survived by his wife and Gianna's mother, Vanessa, 3 daughters, Natalia, Bianca, and Capri, parents Joe and Pamela Bryant, and sisters Sharia Washington and Shayatab. El Segundo has been home to the LA Lakers for many years, and the entire Lakers team is a special part of the El Segundo community. At this time, we'll hold a moment of silence for 24.2 seconds to signify Kobe's number 24 and Gianna's number 2 jerseys.